Not mentioning a contempt application.
Huh? ও এটা আমাকে দিয়েছে। ঠিক আছে, ঠিক আছে।
Any mentioning?
Mentioning contempt application.
Contempt arising out of
WPA 1202/2023. Your order, my lord.
which order? Passed by this court.
Yes, my lord.
Huh? Where is the order? Where is the order?
Not order, I don't have it right now.
Bring the order.
Lord, mentioning a inclusion of motion, my lord.
Motion
Inclusion motion.
of which court?
Sport, my lord.
Equity motion pending আছে?
কোন ইয়ারে?
15.
15
গ্রুপ এখানে লেখা নেই।
গ্রুপ 1 আমাদের কাছে আছে।
Find out if there
গ্রুপ 1 হলে এখানে হয়।
ছেড়ে দিন। Next.
Mentioning for the inclusion of contempt matter.
Contempt of which court's order?
Scope.
Bring the order.
I don't have the order.
Mention tomorrow.
Item number 1. Well, this is my application for restoration. My lord, my learned friends have filed their opposition. It was filed belatedly just before the vacation. But we require another 10 days time to file our reply.
You'll be filing your
Reply, my lord.
reply. Mr.
My lord, I filed my affidavit in opposition. One thing, my lord. To shortcut this matter, my lord, I have taken the point, my lord, that there is a requiring body, my lord. That requiring body is not a party of the proceeding. In the meantime, my lord, they will file an application for requiring body. Otherwise, requiring body is not a party of the proceeding.
My lord, my learned friend, with the deepest of respect, is unnecessarily convoluting the matter. My lord, there is a writ petition which has been dismissed. This is an application for restoration of that dismissal matter. My lord, my learned friend now says that an authority was needed to be implemented in the original writ petition. That will be considered if your lordship is pleased with my application and is pleased to restore the matter. Not now, at the stage when I'm saying the matter has to be restored.
Which are the item numbers you are
My
appealing?
lord, I am appearing in the first item.
Mr. Rupak Ghosh, learned advocate appearing for the petitioner. Acha, affidavit in
Item number 1.
filed on behalf of respondent number 2 is taken on record. Copy served. Mr. Canpara. Mr. Rupak Ghosh, learned advocate appearing for the petitioner, seeks extension of time to file his reply. Let such reply, affidavit in reply, be filed by the petitioner within a week.
My lord.
Within a week from date. Release this matter after 1 week.
My lord, so deeply. Item number 2.
Lordship, this is my application for restoration. Lordship, there has been a delay of 407 days in filing this application for restoration. Your Lordship, the order of dismissal was passed on 30th August 2023, Your Lordship. Due to some miscommunication with the clerk of the learned advocate, and the learned advocate was on his legs before another court. So,
of the copy of the application, there is a delay of
407 days, Your Lordship. It is can number 2, Your Lordship.
2. Affidavit of service. Who is for the state? Sir, land acquisition officer. 5, 6,
So earlier Mr.
Okay.
Sadananda Ganguly was appearing for the state.
7, next step.
All I'm saying is that Lordship, that the delay may be condoned and the matter may be restored.
State. Sadananda Ganguly is in the panel. No, Mr. Sadananda Ganguly is in the panel, right? Affidavit of service filed on behalf of the petition is taken on record. Learned advocate petition is directed to serve copy of the applications upon in the office of the government leader. To serve the copy of this application upon the government leader.
Yes, Lordship.
Is this matter after 2 weeks? Affidavit service তো বলুন। ঠিক আছে।
Weeks. Item number 3.
Lordship, this is my application for restoration, Your Lordship. The
My name was the GP of, but I have not any copy of any.
Lordship, let the matter be restored. We shall file our.
Huh?
We shall serve a copy of the writ petition, but
Mr.
unless the matter is restored, Your Lordship.
Shondi Charan De, learned additional government leader, submits that the copy of the application has not been served. Will you filing in opposition?
I have seen that, but after that.
Okay.
Lordship, may I file the affidavit of service?
Learned advocate for the petitioner, Paracole, undertakes to serve copy of the applications. List this affidavit of service filed on behalf of the petitioner is taken on record. Opera the other. List this matter up to 1 week. After a week. Next.
Item number 4.
Stand for the petitioner, Lordship.
I appear for the respondent.
Lordship, this is my affidavit of service, Lordship.
What is this application?
Lordship, can 1 is for restoration and can 2 is section 5, Lordship. There is a delay of 52 days.
How many?
52 days,
52.
Lordship. Lordship, it was dismissed on 30th of January 2024, Lordship. My explanation is from paragraph 5 onwards, Lordship. That on and from the middle of October 2023, the petitioner, due to some unavoidable circumstances at home, and further due to severe property dispute in the family for which the petitioner became highly perturbed and badly engaged, and further most of the time was required to go out of city, for which the petitioner failed to contact his learned advocate to know the status of the case. Thereafter, on 20th of April, he contacted his advocate, but he came to know that it was listed on 30th of January 2024 under the heading contested hearing. But since no one appeared, Lordship, it was dismissed for default.
Yes. Last one. Can affidavit of service filed on behalf of the petitioner is taken on record? Who is for the state in this?
Must have been served, Lordship.
You have some?
Yes.
Okay. Can 2 of 2024. This is an application for condonation of delay in filing the restoration application. So and so learned advocate appearing for the petitioner submits that due to certain property disputes in the family, and at the same time the petitioner was required to go out of the city. He could not contact his learned advocate, which has resulted in dismissal of the application. Writ petition, sorry. Writ petition. Dismissal of the writ petition. He prays for condonation of delay of 52 days in filing the writ petition, filing the restoration application. None appears on behalf of the state respondents. Mr. Satyajit Talukdar, learned advocate, representing the respondent number, respondent number 3 to 6, leaves the matter to the discretion of the court. On going through the amendments made in the application, it is found that the cause shown is sufficient to condone the delay of 52 days in filing the restoration application. Accordingly, the delay in filing the restoration application is condoned. Can 2 of 2024 is allowed and disposed of. Can 1 of 2024, this is an application for restoration. Similar submission. Considering the amendments made in the application, the submissions advanced on behalf of the petitioner, the writ petition is restored to its, the order dated 30th January 2024 is recalled. Stop. The writ petition being number, writ petition is restored to its original file and number. The application being Can 1 of 2024 stands disposed of. The affidavits have been filed.
No, Lordship. There was an order, Lordship, dated 23rd of September 2015, directing the state to file their affidavit.
And
but Lordship, till date, they have not filed. At least we have not received.
KMDA has filed.
No, they have not filed. Only direction was upon the state, Lordship.
None appears to get it. Mr. Shruti Talukdar's সাথে? Have you got any objection to the application for restoration?
Regarding restoration, we have.
Leaves the matter to the discretion. এবারে দুজনের, হ্যাঁ? Mr. Talukdar for the KMD and so for the state respondents. Leaves the matter. Read petition heading করুন WPA 24073 of 2015. Both the learned advocates representing the state respondents as well as the respondent number 6 to Mr. Talukdar 3 to 6. 3 to 6 KMDA seeks extension of time to file the affidavit in opposition. Let such affidavit in opposition be filed within a period of 2 weeks. Reply. What is this matter about? This is compensation?
No, Lordship, allotment, Lordship, alternative allotment of land. We were land losers, Lordship, under a scheme of the then Calcutta Metropolitan Development Authority.
Okay.
But Lordship, we were not provided, Lordship, alternative plot.
Seeking time, my lord, at that point of time, there was no such scheme. But a decision was taken for the time being.
Okay.
And to identify the land losers, and we had allowed. Why the petitioner was not allowed that? So
Let such affidavit in opposition be filed within a week, within 3 weeks, within 3 weeks. Reply within 1 week, 2 weeks. List this matter after 5 weeks.
Item number 5.
It's my application for restoration, Your Lordship.
How many days?
There's been a delay of 585 days, Your Lordship.
Oh, what is delay? Which one application is for delay?
Application for delay is, Your Lordship, can number 2.
Can?
Can 2 of 24. Your Lordship.
And what is 3?
Can 3 is not my application, Lordship. Can 1 is the restoration application and can 2 is the.
Can 3 is not your application.
Your Lordship.
Then signature of the advocate is Amit Chaudhary. Who is Amit Chaudhary?
Is I'm thinking.
I do not have.
One is for restoration. 2 application is for restoration.
There must be some mistake on the part of my instructing advocate.
Why 2 application? In this, the affidavits have been filed in this.
Yes,
Everybody
matter is
said-
ready for hearing and paperwork has also been filed. Sent to the direction passed by the honorable court, my lord. Petitioner filed. This is a compilation of papers.
Variables are completed.
So,
I'm saying if the delay may be condoned, Your Lordship, and
what is 3 and what is 1?
can 1 is, Your Lordship, the restoration application.
And 2?
And 2 is the application for condonation of delay. And
Almost a delay. You have the copy of the application, can 2?
yes, Your Lordship.
5 days.
585 days delay, Your
The
Lordship.
can 2 is also for restoration.
Can 2 is for condonation of delay, Your Lordship. Yes, sir.
You have the copy.
Yes, Your Lordship.
দিয়ে দিন দেখে ঠিক করে can 2
Your Lordship, that has been an inadvertent error on the part of the clerk filing it.
can 2 is for restoration. Can 1 is for restoration. How many restoration applications we Oh, I think one has to be not pressed. Ah, ये कौन application move করবে দেখ তো দেখ first you go through the prayers of the application and then you press the applications which you intend to do.
Actually, it appears that there was a previous restoration application on board. It was not informed me. Your Lordship, I'm not pressing can 1.
Can one?
Can 2 is the restoration application and can 3 is the application for
Yes.
condonation.
So Talukdar,
Same application. Numberটা আপনাকে ভুল দিয়েছে। এটা হবে can 2 আর ওটা হবে 3 বাটটা ভুল লিখেছে not present.
is there any objection to the press?
Offered my respectful submission.
What has been said? Fail to inform.
Lordship, the learned advocate
She will consider, I'm not going to file any affidavit in opposition. But the explanation are proper sense. So 585 is delay shows that the petition was not at all resilient.
Can one of 2023? Learned advocate for the petitioner not press the application. Accordingly, the application being can 1 of 2023 is dismissed as not pressed. Can T of 2024, this is an application for condonation of delay in filing the application for restoration. Mr. So-and-so, learned advocate for the petitioner, submits that the at the stage of hearing, the petitioner failed to take steps resulting in dismissal of the writ petition. The petitioner also failed to contact his learned advocates and steps could not be taken within the stipulated period for restoration. He seeks for condonation of delay. Mr. Satyajit Talukdar, who is for the state? Come this side. Now, Mr. Satyajit Talukdar, learned advocate for respond numbers. 4, 5, 7, and 8 submits that the cause shown in the application for condonation of delay is insufficient. And as such, the application should be dismissed. Two এর heading করেছেন তো? Three of 2020. Mr. Sen,
The same submission.
একই করে দাও।
Explanation.
I'm going through the amendments made in the application. And more so, the matter is ready for hearing. The cause shown for condonation of delay is accepted. Accordingly, the delay of 585 days in filing the restoration application stands condoned. The application being Can 3 of 2024 stands allowed and disposed of. Restoration is to the prayer to restoration. Submission the same. Finding to same application Can 2 of 2024 is allowed. The order dated 9 February 2023 is recalled. The writ petition being number to the government. The petition is restored to its original final number. WPA 119 of 2018 at a heading করে দিন। Is this matter? When, Mr. Talukdar? When can it be heard? Any day. Follow hearing a date. How do we get up? 19th, 20th, এরকম দেখ 20th January.
Lordship may be permitted to file my affidavit of service.
Affidavit of service.
Leave may be granted to correct the CAN numbers in the affidavit of service, Your Lordship.
Leave granted. Affidavit of service. Now, order opposite on the prayer of learned advocate for the petitioner. Leave granted to correct the CAN numbers in the affidavit of service. Okay, affidavit of service filed on behalf of the petitioner is taken on record. Yes, correct.
Instead of 28,
Friday, then 21st. The 20th now, 21st, then second half it will be Wednesday. No, 16 তারিখে না 21 তারিখে 21st, second half.
Gratefully. Service.
Deeply obliged.
Yes.
Item number 6.
Item number 6, my lord, I am appearing for the applicant, my lord. My lord, perhaps, my lord, my video has been stopped by my lord. My lord, my video has been stopped, my lord, by the court, my lord.
By the court.
Yes, my lord. My lord, you cannot start your video because the host has stopped it. It has been shown in the display, my lord.
Okay. I just find out.
My lord, this is an application for restoration, my lord, and it has been filed in due time.
Wait.
As your lordship, my lord.
Level.
Yes, my lord. My lord, this is an application for restoration, my lord, and my lord, the application has been filed in due time, my lord.
Okay.
My lord, and my lord, the affidavit, there was a direction for exchange of affidavits, my lord, and it has already been affirmed and filed, my lord.
Who is for the state?
For the state.
What is your any opposition? You are for Union of India. Is there any opposition to this application?
ফাইল করেছে
Not to
Yes, my lord.
the CAN application. Have you filed any opposition to the CAN application?
No,
You-
my lord, there was a direction to file affidavits in connection with the writ petition, my lord. My lord, the CAN application has been filed in due time, my lord.
This has been served upon you. Have you got any objection to this application? Yes, sir. Ashut. CAN 1143 of when it was dismissed?
My lord, on 3rd January 2020, my lord.
Uh, ach. This is an application for restoration of the writ petition upon recalling order dated 3rd January 2020. Miss, here appeal.
Mousumi Bhawan, my lord.
Ms. Mosumi Bhawan, learned advocate for the petitioner, submits that the application for restoration is filed within time. He seeks for restoration of the writ petition. Learned advocates appearing for the state respondents as well as Union of India is the matter to the discretion of the court. It is found that the writ petition was dismissed for default on 3rd January 2020 and the application has been filed on 4th February 2020. Stop since the application is filed within time. The prayer for restoration stands allowed. The order of dismissal dated 3rd January 2020 is hereby recalled. The writ petition is restored to its original filer number. The writ petition act heading করুন. The affidavit in opposition has been filed.
Brings extension of time to file an opposition.
Mr. So-and-so, writ petition, Mr. So-and-so, learned advocate for state respondent seeks extension of time. You are 2, 4 and 9. Time to file affidavit in opposition. State respondent, let such affidavit in opposition be filed within a period of 2 weeks. Please this matter. Reply thereto if any be filed within a week thereafter. Release this matter after 3 weeks. And
Grateful to your lordship, my lord.
Item number 7.
Lordship, I make please Lordship, my lord, I beg to appear. I beg to appear on behalf of the petitioner.
yes,
My learned friend, Ms. Banerjee, who is physically present before Lordship. I have a prayer to file a supplementary affidavit. We have prepared the supplementary affidavit. We have also filed a copy of the supplementary affidavit on the other side. Possibly the other.
this was dismissed for default.
Restored there.
Restored. What is the stage now? The state is to file the oppositions or going to file? Yes.
State
Affidavit.
has,
Yes. Mr.
state has not filed any affidavit.
Or not filed. Who appeared for this state? Give a notice. What is CAN 3? CAN 3.
It's an application for appropriate order
Appropriate order.
that was intended to expedite the hearing of the matter itself.
They have filed their opposition? No.
No affidavit whatsoever in any matter.
Give a notice. Fixing a date for hearing. এটা দেখো তো এটা অ্যাসাইন্ড হয়েছে একটা ডেট দাও হিয়ারিং এর ইন দ্য মিন টাইম সার্ভ আ নোটিস মিস্টার চণ্ডীচরণ দে ইজ ফর দি স্টেট এক এক সপ্তাহ পরে একটা ডেট দাও গিভ আ নোটিস হ্যাঁ
My lord, if it's not inconvenient, my lord, make it 2 weeks.
2 weeks Mr. Sukhdev Mukherjee learned senior advocate appearing for the petitioner submits that the state has not yet filed its affidavit in opposition.
We have not been served, my lord. If it is filed,
And-
we are behind.
Neither any copy of such affidavit in opposition has been served upon the petitioners. It is informed by the learned advocate that Mr. Chondi Charan De, learned additional government pleader, appeared for the state respondents. Learned advocate for the state petitioner is directed to serve a notice upon Mr. De, learned AGP, intimating the next date of hearing. 2 সপ্তাহ পর ডেট বলুন 15 জানুয়ারি
Grateful lordship.
আর ওপরে অ্যাফিডেভিট অফ সার্ভিসটা নিয়ে
Item number 8. Well, 8 I'm for the respondent, my lord. I was addressing my lord.
You
But that matter,
দেবদূত মুখার্জি এটা কিছু নোট নিয়েছিলাম নোট কিছু নেওয়া আছে কোনো কাগজ আছে দেখো কাগজ নেই না 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 লাগবে না ধরো আছে একটা কিছু
after the
Oh, no, notice was served. Notice was not served.
that is their condition. When I was concluding.
Not served, and there was violation of natural justice and arbitrarily that was got to be repossessed. I had concluded my argument on the last
Just that they were the paucity of time. We had only 5 minutes more. It's that matter, my lord, where there is this sought for an initially, my lord, kindly comes just short.
Yes.
My lord, kindly just that they had mentioned, my lord, 3 or 4 dates, my lord, which were relevant for the adjudication of this matter. My lord, just recalls, my lord, the deed of lease was of 28th of March 1984 was the deed of lease. Then the possession was handed over on 24th of May 85. That is one year after that. 84 lease deed, 85 possession handed over. They were supposed to construct by 3 years. First time they sought extension from us was in 1996 after 11 years. 84 lease of deed, 85 possession, 1996 was the first time when they sought permission from us. We granted them a year's extension. Thereafter, again, after they did nothing, sat tight over it. Again, after 11 years, that takes us to roughly 22 years for extension, and now to this nearly from 1984, it's 30 years down the line. Right? 30 40 years, 84 থেকে 2024.
1994 extension.
1984 deed of lease.
The extension
First extension was in 1985. Possession we give them. Possession was given in 85.
Huh.
Lease deed was of 84. Possession of 1985. First time they sought permission from us was in 1996. That is after 11 years.
Fix.
They were supposed to do the work within construction within 3 years, but after 11 years, they came and said that we could not have done. Kindly permit us sometime. We permitted them 1 year.
Therefore,
Again from 1996, satellite, nothing. In 2007, again another 11 years.
extended. 2011, then what happened in
1996, then 11 years, then again in 10th of September 20, after 11 years, Malon, we give them a notice. That notice is under challenge. Now, the point which raised for consensus was that whether
2007 notice was given.
yes, 2020, well, it kindly comes to the writ petition at page.
Yes.
Well, it kindly comes to the my supplementary affidavit, madam. My supplementary affidavit, page 5. But this leave was sought by Leadership Honorable Subra Ghosh, my lord, kindly comes. Supplementary affidavit, page 4.
Hmm.
This was the order passed on 10th of April 2024.
No notice and
Leave was granted to the state respondents to file a supplementary. My lord, will kindly comes to page 5. Page 5, I have annexed the notice. Notice dated 10th of September 2007.
Hmm.
To Mr. Jivan Das Bajaj, allotment of plot number 186, my lord. Then, and whereas plot number Bidhannagar was leased out to Mr. Jivan Das Bajaj by the governor of the state of West Bengal by a registered lease deed executed in his favor on 28th of March 1984, inter alia with a specific condition laid down in clause 26A of the lease deed that the lessee shall construct the building on the demised land within 3 years from the date of possession of the demised land, all such extended time as may be allowed. Then, and whereas it reveals from an inquiry, first 84 was the lease deed, next paragraph 85 is the possession given, next paragraph, and whereas it reveals from an inquiry that the plot is still lying vacant, then, well, it kindly comes to the last paragraph of that page, whereas the governor of the state of West Bengal is pleased to serve upon him a notice under clause 4 of the aforesaid indenture to remedy the breach caused by violation of clause 26 of the lease deed within 6 months from the date. This was the notice. The resumption was done. Well, they challenged this. Well, one thing which rose that this notice which was sent to them by register post with AD, they say that they have not received. This is one. Others, admittedly, there has been a from 84 it was the allotment. Today is 2024, 2025, 2024, 40 years. We have resumed the possession. It was lying vacant. 11 years for two terms. They sought for extension, nothing done. My learned friend has taken, showed a judgment of this. Copy Sanjeev Bhagat and others petitioners versus Union Territory.
Hmm.
Pertaining to Chandigarh leasehold of, well, kindly the copy of the judgment. Well, this is the judgment which my learned friend relied, and my only thing was that I was supposed to hand over judgment. Well, kindly takes this. এটাই তো কবিতা সাহা N. Well, this is the judgment that day which I was relying upon. Well, exactly on same point, whether what, whether this is of
WP 3126 of 20 Kavita Sahab, may I just go through the judgment? The short question which arises for consideration in this writ petition pertains to the exercise of the power of resumption by the land manager Bidhannagar government of West Bengal of a plot of land being premises number 47 in block FC sector 3 of Bidhannagar, Salt Lake property. Shown of details, the brief facts culminating in the filing of this writ petition are as follows. By a deed of is going
Yes, yes.
by a deed of lease dated 14th of September 83, ours is 84, executed by the government of West Bengal in favor of one Sudhir Chandra Poddar since deceased, the premises was leased for a period of 999 years to the original lessee with an express condition that a residential building would be constructed within a period of 3 years from the date of possession of the demised land or within such extended time as may be allowed by the state government in writing. On 11th October 1991, Sudhir Chandra Poddar died. Significantly, no residential house had been constructed on the premises as on the date of his death. Subsequent to the death of Sudhir Chandra Poddar, a mutation certificate dated 20th of October 2002 pertaining to the premises was issued to the name of the legal heirs. On 26th of December 2005, a show cause was issued under clause 26A. Here also we have issued of the lease deed in the name of the co-lessees pertaining to their failure to make any construction on the premises. Pursuant to the aforesaid show cause, various opportunities of hearings were held on 12th of January. And these are the dates. In the meantime, 2 of the mutated co-lessees also expired. On 23rd of May, a mutation certificate petitioners applied for transfer, departmental inquiry. In the aforesaid background, the respondent issued a resumption order. This is what we have done in this case also under clause 26A. Then while the sanction plan is an alleged, now comes these are the facts which are given in the internal page 5, para 3. It is in this background that the present writ petition has been filed, primarily challenging the improved notice whereby the respondent number 3 had cancelled the offer of allotment. Same pattern, the point, exact facts are same. In favor of the petitioners and requested the petitioners to hand over physical possession. Here we have taken possession. Now, Mr. Basu, appearing on behalf of the writ petitioners, has strenuously contended that under clause 26A of the lease deed dated September 1983, the respondent authorities had a discretion to extend the time for constructing the residential plot. My learned friend also had same line of submission. As such, according to him, time was not of essence of the lease and the period of 3 years as stipulated under clause 26A was extendable. He submitted that admittedly as on date, construction has taken place. In our case, no construction. He further submitted that the delay in making the construction was beyond the control of the petitioners and was for unavoidable reasons. He submitted that the order of resumption is a drastic exercise of power by the respondent authorities and is contrary to the doctrine of proportionality. In support of his contention, he relied on the decision reported in Terry Oat Estates. Why I read that judgment which was shown by my learned when Chandigarh judgment, this judgment Terry Oat, this considers that judgment also. This judgment is considered. May I hand over the book? This judgment, which was considered by Justice Kapoor, this is that judgment which has been also referred in the Chandigarh judgment. Same. That has been taken. Now kindly comes, he further submitted that in the facts and circumstances, there is a complete arbitrariness on the part of the respondent authorities in issuing the improved notice. When I'm going to the judgment passed by Justice Kapoor. Then Mr. Banerjee, advocate appearing on behalf of the respondent authority, submitted that the petitioners have approached this court with unclean hands and the entire case of the petitioner is based on suppression and distortion of the true and correct facts of the instant case. He submitted that any construction which has taken place on the premises has happened subsequent to the impugned notice. He submitted that the petitioners have entered into a fraudulent transaction, while these are not facts of his case. The main contention of the petitioners is that the impugned notice has been issued without considering the explanation given by the petitioners to justify the delay in completing the construction. By letters dated such and such, the petitioners had sought to explain the reasons for the delay. Then, my lord, comes these are the facts, and clause 26A is set out at paragraph 7. These are the 26A, the notice which we have given. Now, it is also pertinent to mention that clause 2(8) of the said lease deed provides that the lessee shall not assign or transfer. In this case, we have taken possession. I am of the view that the improved notice contains sufficient and justifiable reasons. Merely, no construction within the statutory period, nothing. You are gone. I am of the view that the improved notice contains sufficient and justifiable reasons and has been issued after full and proper consideration of the facts and circumstances of the case. It is an admitted position that from 1983 till the date of issuance of the notice. In my case, from 84 till 2007. No construction of any building had been carried out in the premises. The delivery of possession of the premises was far back as 1984. On a plain and proper reading of clause 26A of the lease agreement, construction of a building should have been completed within 3 years of the lease agreement or within a reasonable period. By a communication dated 2005, an opportunity was also given to the petitioners to remedy the breach and complete construction within 6 months. Here we have given them 1 year time from the date of issuance of the notice. The petitioners had applied for mutation. Then I also find from the affidavit filed on behalf of the state respondents that it is evident that they have given it to someone. I am therefore of the view that there is a clear and categorical violation of clause 6A. It is well known, paragraph 12, my lord, it is well known that transfer of land in Vidhannagar municipality has always been a complicated issue. There are a number of plots in area which are still lying unutilized, though the lessee has taken delivery of plots from the state government a long time ago. In some cases, the lessees have become unable or are unwilling to develop their respective plots. In other cases, the lessees, because of financial constraints, are unwilling to construct and have entered into ways and means of transferring their plots to third parties for valuable consideration. Admittedly, these plots have been leased out 2 or 3 decades ago and the property prices have increased drastically. Now, third parties for valuable consideration attempt to transfer the plots in their names. Diverse means for circumvention, such as executing a general power of attorney, entering into agreement for lease, tenancy, and creation of a will in favor of strangers, have been devised of to get around and the restriction on transfer, which had been granted decades ago. In recent times, I am informed that the state government have taken steps in order to streamline the entire process and ensure that unutilized plots, both of industrial and commercial lands, are to put to effective use. I am also of the view that the fact that a building or some construction has been carried out and completed, but here in my case, there has been no issue. There is absolutely no lawful justification or explanation for the petitioners failing to carry out a consideration for more than 35 years. It is evident that the intention of the petitioners in challenging the impugned notice is dishonest and with ill motive. It is evident that the petitioners are interested in inducting third parties and are creating third party interest in respect of the premises. I am of the view that to exercise any discretion in favor of the petitioners in the facts of the instant case is to reward a party who is not only in breach of its contractual obligation but also has been indolent and lackadaisical. This is in clear violation of the letter and spirit of the lease agreement. It is fundamental to writ petition that if a claim made by the petitioner is frivolous, vexatious, or prima facie unjust, the court would decline to invoke its extraordinary power. The courts have also repeatedly emphasized that a writ petitioner must come to court with clear hands and it is impermissible to approach the court for an oblique or ulterior motive. It is also well settled that the decision vested in courts under Article 226 of the Constitution is a judicial discretion to be exercised according to judicial principles. Accordingly, in the light of the admitted failure on the part of the petitioners in complying with their contractual obligations for more than nearly 3 decades, I am of the view that the writ jurisdiction cannot be invoked to support an unjust claim made by the petitioners. I am also of the view that the writ jurisdiction cannot be invoked and was never intended to encourage and facilitate avoidance of obligations voluntarily incurred by a party. And the Terai judgment which I have handed over just now, my lord, this was also dealt with. The decision reported in Terai Oath cited by the petitioners is distinguishable and inapplicable to the facts and circumstances. In fact, in the said decision at paragraph 20, it has been categorically observed that when the intention of the allottee is dishonest or with an illegal motive, the power of resumption can be invoked by the concerned authorities. We have resumed it. In any event, the facts of the instant case are clearly distinguishable from the fact of the aforesaid decision. As stated herein before, it is an admitted position that the petitioners have done absolutely nothing since 1984, same case here, and are now attempting to benefit third party strangers, that is up to them to original listing. I am fully aware of the fact that the respondents have also delayed in invoking the right of resumption. They said that the lordship says that we should have resumed it much earlier and have kept the matter pending for too long. Moreover, it is true that to an extent, because of the possible delay in furnishing of the mutation, however, I am of the view that in the particular facts and circumstances, petitioners are not entitled to enjoy a premium nor any vested right be said to have accrued in their favor in the light of their admitted failure. To honor their aforesaid writ petition, they have, I find no merit, no grounds, and the input notice of resumption. These are the absolutely facts of the case. In the present case, 40 years stood nothing from to extension, 11 years, again 11 years. And the question of notice, my lord, I am well covered under the General Clauses Act, my lord, need not repeat anything. Once the notice has been sent to the correct address, and they are aware of this, and even if in 2007 also, in the agreement itself, 26A, which was executed in 84, that time also, why should they wait for a notice? 84, malad, I should have done in 3 years. 85, I take possession, malad. But these are my humble submissions. Absolutely taking the court for a ride and making submissions which are not tenable in the eye of law. Well, this should be not only dismissed, but dismissed with exemplary recourse.
Well, the language used in the lease deed, my lord, will find at page 28 of the writ petition. The proviso says that provided nevertheless, at page 28, my lord.
Only that. One matter before Justice Chakraborty's bench.
My lord, page 28 kindly looks at the proviso. Clause 4 proviso. Provided nevertheless, the lessor shall not exercise the right without serving the lessee a notice in writing giving 6 months time to remedy the breach. So this existence and service of the notice is mandatory to exercise the right to re-enter the property. Now, my lord had seen their affidavit in opposition. Kindly sees their affidavit in opposition where that they had filed. The fact that the time was extended in June 11, 1996 is at page 4, clause F. 3 subpara F at page 4. Has my lord found it? So they are saying that in June 2008, June 11, 1996, writ petitioner department further allowed 1 year extension of the time in order to complete construction of the residential building. It is further stated, writ petitioner again miserably failed to take the opportunity of this time extension to provide even after 11 years from the date of extension till September 9, 2007, he failed to construct the residential building on the plot of land. Then H, my lord, it is stated as per the plot was lying vacant, peremptory final notice was issued to the writ petitioner. So this is the notice that was issued, which is the contention in their affidavit in opposition. But strangely, they did not annex this notice to their affidavit in opposition. The writ petition was filed in the year 2019. 4 directions were been given by this learned court to file such supplementary affidavit. My lord, those orders I'll just indicate. Those orders. First one was 10th of April, my lord, of 2024. Second, my lord, 13th May. My lord, yes, my lord. Yes, my lord. As I recall, there have been at least 4 directions, and it is only in December 20, 2024, that this supplementary affidavit containing this notice, so-called notice, was filed before this honorable court. Now, kindly seize the notice, my lord. General Clauses Act was referred to. If it is correctly addressed and posted with appropriate stamp, my lord, then it shall be presumed that the notice was served. Now, if my lord kindly sees the supplementary affidavit at page 5, the notice is there. It is of 10th of September 2007. Kindly sees right on top right-hand corner, it is mentioned registered with AD. If they had produced the postal receipt, we would have understood, my lord, that this was actually correctly addressed, postage stamp was given, everything. I do not find the postal receipt in this supplementary affidavit, my lord, or anywhere next to the notice. Now, kindly, my lord, why I say that my lord should not only they should disbelieve this notice, It is because of the contention that they have made it themselves in their affidavit in opposition. Kindly take the affidavit in opposition once again. I had read till paragraph, subparagraph H. Now kindly seize, my lord, subpara I at page 5. It is also further stated that the above mentioned peremptory final notice was also sent to the Director of Information West Bengal such and such department dated 12th of August 2008 for publication in daily newspapers. My lord, if a notice was served, what would be the necessity to cause any publication in any newspaper? That newspaper also is not before my lord. They could have disclosed it in the supplementary affidavit. They did not. And my lord, what is my contention in the writ petition which has not been denied by the respondents? That the possession was taken in November 2016. So if a notice is issued in 2007 and 6 months time is given to remedy, why would they wait till 2016 November to take possession? It is a humble submission that they have not acted in accordance with the lease deed, the terms, and this notice was never issued. Even if it was lying in their office. There has been no attempt to serve it on me. And if they did actually serve it on me, then why would they require to publish in the newspaper? Now, secondly, my lord, the judgment that was referred to by my learned friend, that judgment kindly comes to paragraph, page number 3 of that judgment.
Wait. Use.
The judgment passed by Justice Kapoor.
Page number?
My lord, page number, internal page 3, my lord, paragraph 2, subpara C. This judgment is clearly distinguishable on facts. Kindly sees on 26th of December 2005, a show cause was issued under clause 26A of the lease deed in the name of the co-lessees pertaining to their failure to make any construction. Pursuant to the aforesaid show cause, various opportunities and hearings were held respectively by the respondent authorities. In my case, the contention is no show cause notice was issued. Question of hearing does not even arise. So, my lord, if there is no notice issued, this judgment cannot be relied on. And, my lord, another thing I must point out, the judgment relied on by my learned friend in the matter of Kobita Shaha versus the state of West Bengal, my lord, has been set aside. Here's the division bench order, my lord, giving them a copy. Kindly seize. My lord, will come to paragraph number 1, which will indicate that this is in respect of an appeal arising out of the writ petition 31206 of 2017. So this is the writ petition order. It was passed on 5th of July 2019. And my lord, this was set aside on 3rd of February 2023. So this judgment that has been relied on by my learned friend, my learned senior friend, is perhaps, my lord, is perhaps not, shouldn't say perhaps, no longer exists today. Now, kindly, I would like to rely on a few paragraphs from this division bench judgment. Kindly seize at page 18 of this judgment, my lord, paragraph number 21. I would rely on paragraph numbers 21 to 24, my lord. Now, the question is whether the appellants are entitled to an opportunity, because the facts have been placed in detail, my lord. I'm not going through the facts again.
Page number?
My lord, page number 18 of that judgment of the division bench. Now, the question is whether has my lord found it? Wait. Page number 18.
Yes.
Now, the question is whether the appellants are entitled to an opportunity of being heard, particularly when the materials on record are suggestive of the fact that the appellant submitted the proposed building plan for sanction before the Bidhannagar Municipal Corporation, and the same was pending for sanction in the relevant point of time. It is also found that the matter was intimated to the respondent number 3, and a prayer was made for extension of time for completion of the residential building. But unfortunately, the appellants were not given an opportunity of being heard over this such prayer, and resumption order was passed from the side of the concerned department. Needless to mention, the construction of a residential building requires preparation of a building plan with the aid of engineers, experts, and other personnel. And thereafter, it is also required sanction from municipal authority, and obviously, it will take some time. It may not have been possible to complete the construction of a residential building within 6 months, as proposed by the respondent number 3 in the mutation order dated such and such. A reasonable and prudent man would know that it is extremely difficult to complete the construction within 6 months, and the same goes through several stages, such as the process of preparation of building plan, obtaining sanction from the municipality, and thereafter engagement of masons, laborers, and other experts to complete the construction as proposed. Even the learned single judge has been pleased to observe in the impugned judgment as hereunder. And my lord, it quotes from the impugned judgment. 23. Therefore, it appears that the mutated lessees tried to get building plan sanction, but were unable to do so within the time period that may have enabled them to complete the construction within 6 months from the date of mutation, due to the time consumed in preparation and getting sanction from the authority. And as such, there is no doubt that the petitioners got a very short period for completion or construction of the residential building. And had they been given some more little time, they might have been able to complete the construction. However, difficulties of the petitioners could have been brought to the notice of the Department of the Urban Development had they been given an opportunity of being heard on their prayer dated such and such. This is a serious, this was, my lord, representation was given, give me some more time, building plan has been submitted. This is serious lacuna on the part of the respondent number 3, and as such, I am compelled to hold that the respondent number 3 committed serious mistake by not affording an opportunity of hearing to the appellants and thereby prejudicing the appellants in exercise of their fundamental rights. Paragraph 24, my lord. Accordingly, the impugned judgment and order and also the relevant resumption order dated 30th November 2017 in connection with plot number such and such, Salt Lake City, Kolkata, along with cancellation, order of allotment, order number such and such dated 1980, and the lease deed dated such and such issued by the Land Manager, Department of Urban Development and Municipal Affairs, Government of West Bengal, Nagaland, Salt Lake, are hereby set aside. So the impugned order was set aside. The precedent that was relied on by the state, my lord, before my lord, is no longer exists, my lord, it was set aside. Now, I asked myself this question, my lord, that if a notice was indeed, because I do not want to make any allegation of fraud or foul play on the part of the state respondent. Ultimately, it's state, not an individual. Why should they do something like that? But I asked myself a series of questions. If a notice was given in 2007, number one, there was no need for publication in the newspapers. Number two, my lord, that they would be able to show service of notice. Number three, my lord, why would they wait till 2016 to take possession of my land? And the proviso to clause 4 states that no action shall be taken. It's couched in a negative language, that if you give notice, then only, otherwise not. So this arbitrary resumption, arbitrary holding of, taking over of possession of the property at Salt Lake, my lord, it is, my lord, it cannot be sustained, because it is definitely in violation of the lease deed. General Clauses Act, which was also mentioned by my learned friend, my lord, is not applicable in this case because they have been unable to produce any postal receipt to show that it was properly addressed, it was properly stamped.
In the writ petition, the order of resumption has not been placed.
No, my lord, I'll just indicate, my lord, the writ petition. From the writ petition, I'll indicate. Yes, my lord will see in paragraph number. I have narrated it that in paragraph number. Yes, kindly see paragraph number 10 at page 5. From paragraph numbers 1 to 9, I have tried to explain the delay, which was caused because of the financial difficulties that I was going through because of my father having passed away. The family business was in ruins. In paragraph number 10, I have stated, your petitioner states that he was shocked, to say the least, to find that on or about November 2016, a signboard has been put up by the respondents in the premises concerned, declaring the same to be government land. Clause 4, my lord, the proviso provides at page 28 that lessor shall not exercise the right without serving the lessee a notice in writing giving 6 months notice to remedy the breach. What is that right? That right is provided in clause 4, which says, provided always that if there was any breach of the terms and conditions and covenants herein on the part of the lessee contained, the lessor shall have the right to re-enter into possession. So not resumption order, but they have the right to re-enter the possession of the demised land or any part thereof in the name of the whole, and thereupon the demise shall forthwith stand determined. So this,
that is, re-entry is presumably there is an order of resumption. Otherwise, how can they re-enter?
That also has not been disclosed. If it has been, my lord, it has not been served on me. It is not there even. It has been
Huh?
nobody's even in the affidavit in opposition or the supplementary affidavit. It has not been contended that any resumption order was passed. My lord, I had in
But they
November.
have submitted that there is an order of resumption.
They have also submitted that the notice was given, but my lord, we have not seen the resumption order till date. I have only taken a picture, my lord, of the board put by them, which is at page 33.
Okay.
This is just, I had built a boundary wall across the plot of land to demarcate it, my lord. And my lord will see there are some potted plants, and over that, my lord will see that this is government land, plot number CK such and such. By order, PMS division, UD department. There is no mention, my lord. There is no resumption order. And even if my lord goes through their affidavit in opposition, I do not think they have mentioned any resumption order with date. My lord, I'm going through the supplementary affidavit. They have only mentioned the notice and nothing else.
Sorry, 16th January 2019 is your last representation for extension of time.
And none of them, my representations, I have been writing to them from 2017, immediately after November. In fact, I had written to them, kindly see, my lord.
From 16 onwards, December 16.
Yes, my lord. Page 34, 30th of November 2016. When I see that signboard put up on my land, my lord, I get scared, my lord. I write to them. I have given them, showing them allotment letter, possession certificate, lease it, everything was given. My lord, and thereafter, my lord, kindly sees page 35. Second paragraph. Sir, I or my spouse are both senior citizen and do not own any residential house or land or flat and stay in rented place. And thus, this is the only land in which I want to construct my own residence. I assure you that I will start construction of my residence within 3 months and complete the construction within 18 months from the approval of plan. We have built the boundary wall and given our inputs to our architect for making the plan few months back. Don't have any issues regarding finance now, and we will be able to take the construction of my residence. Well, unless if we own a land, we are not eligible for this.
Do you have your sanction plan?
My lord, I have applied for it, my lord, but because of this taking over a possession, my lord, kindly sees, my lord, I have applied, that is at page 36. Received building plan with following enclosures, again, plot number such and such, 186 in block CK. This, my lord, has been, because this is under Bidhannagar Municipal Corporation, my lord, I had applied for the sanction plan. Yes, 16th of January 2017. I had applied for it, my lord. And thereafter, I have been writing to them, my lord, respondent, which is from page number 37 to. Yes, my lord. From 2017 till 2019, my lord, I had issued several letters. Not one of them have been responded by the response state. My lord, not once it has been mentioned that this clause 4 notice was issued to me, or that a notice was published in the newspapers. Since I was not receiving any response, my lord, I had to come before this court.
Okay.
But I am a single individual, my lord.
What is the order of resumption when it was passed?
The order of resumption that I can get, what I can get is that in the final peremptory notice dated September 10th, it has been stated that if he fails and neglect to remedy the aforesaid breach by getting the building plan sanctioned by the competent.
But after the notice, any order of resumption?
It itself is for the notice for the re-entering. It clearly indicates that the no further notice or this itself to be treated as final and peremptory notice, and no further notice of or reference shall be made for taking necessary action for re-entering.
This is the final one.
This is the final.
Further notice or reference shall be made for necessary.
So, my lord, there is no resumption order.
Itself is the re-entering or the final notice.
Shall stand determined and the government will re-enter. Okay. Ashwin.
Lordship, may I pray for humble passport because Mr. Das is coming from the.
Let him come only. Hearing is concluded. Yeah?
May I take my lord's leave, my lord?
This writ petition is filed under Article 226 of the Constitution of India, challenging the action of the state action of. You are representing the state respondent.
It has been resumed already.
Already resumed.
Yes.
You know,
That's the thing.
challenging the action of the state respondents
এখন কি সেটা শেষ করছে?
in determining the lease and
এই হয়ে গেছে। এটা কি ওরা দিল?
taking over
হ্যাঁ, হ্যাঁ।
possession of the
আমার জানা ছিল।
plot, taking over possession of the plot allotted
After I went, what
in favor of the petitioner.
Hey, this is my copy, no? Thank you. Then nothing remains now.
The brief fact of the case is as follows. Roman 1 করে দেবেন। A lease deed was executed for residential purpose by and between the state of West Bengal and the writ petitioner on 28 March 1984 in respect of premises number CK 186, sector 2, Salt Lake City, Kolkata 700064. The possession of the said premises was handed over to the petitioner on 24th May 1985. As per the lease deed, the petitioner was supposed to complete the work of construction within a period of 3 years from date of delivery of possession. By notice dated 10 September 2007, the lease was determined and combination 2007 বললাম না 7 10 September 2007 the next paragraph determined signboard was affixed on the premises on or about November 2016, declaring that the premises is a government land. Government land inverted comma is a government land. Being agreed by such action of the state respondents, the writ petitioner has filed the present writ petition. The state respondents keenly content contested the writ petition by filing its affidavit in opposition. Denying inter alia the allegations made in the writ petition and content is as follows. The writ petitioner violated that as per the clause 26A, 2 our 6টা ভেতরে A of the lease deed, the writ petitioner was required to complete the work of construction within a period of 3 years from date of taking over possession of the said plot, that is from 24th May 1985 to 24th May 1988. However, however, no work of construction was made for a period of almost 11 years since the plot was demised. On 11 June 1996, the writ petitioner was allowed 1 year extension of time to complete the work of construction of the residential building. However, in spite of such extension of time, the writ petitioner failed to construct the residential building. So, finally, on 10 September 2007, peremptory notice was issued invoking clause 4 of the lease deed to remedy the breach caused by the writ petitioner in violating clause 2(6) of the lease deed. কি বললাম? Notice issued বললাম? Peremptory notice was issued বললাম না? Paper publication was also made in the dailies for causing service of notice, of such notice. Para. Since the petitioner violated the terms and conditions of the lease deed, and also did not remedy the breach caused, the lease deed says the lease did not. The lease was determined. Such action of the state does not call for interference. Para. In light of the above, the writ petition should be dismissed in limine. Para. Mr. Devdut Mukherjee, learned advocate appearing for the writ petition, submits that as per clause 4 of the lease deed prior to exercising the right to re-enter into possession of the demised land upon determination of the lease, the lessor is required to serve the lessee a notice in writing, giving 6 months' time to remedy the breach. Stop. In the present case, no such notice was ever served upon the writ petitioner prior to re-entry into possession of the demised land. Therefore, the action of the state of re-entering into possession is illegal and beyond the scope of the lease deed. The writ petitioner was not afforded any opportunity to remedy the breach. To buttress his contention, he relied on the decision of Honorable Punjab and Haryana High Court. Passed in Sanjeev Bhagat, Civil Writ Petition 25947 of 2012. He seeks for the removal of the signboard affixed on the premises and also for extension of time to complete the work of construction. On the contrary, Mr. Nabokumar Das, learned advocate appearing for the state respondents, submits that there has been a violation of the terms and conditions of the lease deed by the writ petitioner in not making construction within a period of 3 years from the date of taking over possession of the demised land. On the prayer of the petitioner, time period was extended for 1 year. On 11th, it was in the year 1996. However, no such work of construction was undertaken. Accordingly, the state respondents issued a peremptory final notice to remedy the breach In spite of such notice, the breach was not remedied. Therefore, the lease was determined by a final notice and the state re-entered into possession of the demised land. There is no illegality in the action of the state in re-entering the possession, since the petitioner has violated the terms and conditions of the lease deed. In support of his contention, he relied on the decision of this court passed in Srimati Kavita Saha and others versus State of West Bengal, reported in WP number 31206W of 2017. He seeks that the writ petition be dismissed with exemplary cost. Mr. Mukherjee, learned advocate for the next paragraph, in reply, at the outset, submits that the decision passed in Srimati Kavita Saha Supra has been set aside by the division bench. In FMA 1069 of 2019. He also indicates that no such postal receipts or paper publication has been placed before the court to primarily suffice that the notice in terms of the lease deed was served upon the petitioner. Next paragraph. Having heard the learned advocates for the respective parties, the only issue which has fallen for consideration is whether prior to re-entry into possession of the demised land, the notice as required under clause 4 of the lease deed is complied with, is served or not, but complied with. In order to examine the aforesaid issue, it would be profitable to reproduce clause 4 এখান থেকে নিয়ে নেবেন page 28 upon cursory reading of the aforesaid clause it manifests that the lessor shall not exercise the right to re-enter into possession of the demised land without serving the lessee a notice in writing giving 6 months time to remedy the breach. নিয়েছো ঠিক? The state respondents has contended in clause H, paragraph 3, that the peremptory final notice was issued. The fact that the notice was served has not been specifically stated in the affidavit in opposition. The state respondents were granted liberty to file supplementary affidavit when was the order passed for this filing supplementary affidavit?
April 2024, my lord.
10th of April. In order to clarify the situation as to whether notice under clause 4 of the lease deed was served upon him prior to re-entering into the possession of the demised plot. In compliance thereof, the state respondents filed supplementary affidavit. Though the notice for determination of the lease and re-entry into possession dated 10th September 2007 has been annexed to the supplementary affidavit. But no such postal receipts showing issuance of such notice or any document, namely track consignment, a report or acknowledgement due card of the postal department has been produced. It has been averred at para 3I that the peremptory final notice was also sent to the Director of Information West Bengal I and CA Department for causing publication in daily newspaper. Mr. Mukherjee, learned advocate for the petitioner, has rightly pointed out that in the event the service of notice as per clause 4 was complete, there was no possibility for having paper publication. It is pertinent to note that no such paper publication has been annexed to the affidavit in opposition or the supplementary affidavit. From the above, it construes that the requirement as per clause 4 for the lessor to exercise the right, for the lessor to serve notice in writing to the lessee, giving him an opportunity of 6 months to remedy the breach prior to exercise of right of re-enter into possession, has not been complied with. This court finds substance in submission of Mr. Mukherjee, learned advocate for the petitioner, that no order of cancellation, relying on Sanjeev Bhagat Sutra, that no order of cancellation can be passed, shall be passed without giving the lessee a reasonable opportunity of being heard. Para. So far as the decision of Kavita Shah, Srimati Kavita Shah Supra is concerned, the same has been set aside in FMA 1069 of 2019. In view of the above, who has affixed that? Who has affixed this board? Land manager or estate manager? It is by order EE. Who is EE? Estate? The picture which has been given, who has?
My copy.
I order EE, BMS division, UD department.
EMS division.
UD department.
You just write it EMS.
BMS.
PMS.
No, what is EE? EE/BMS division? This falls under which respondent? Land manager.
Must be under the land manager.
Okay. In view of the above discussion, the respondent number 4, the notice of, where is that notice? Notice number 2418 SL within bracket AL/CK-186 dated 10th September 2007 of Urban Development Department of Deputy Secretary, Urban Development Department, Government of West Bengal is set aside. ওটা বলবো না 10th September 2007 and order of resumption pursuant thereto, if any, is also in respect of premises number ওর দিয়ে দেবেন ওপর premises নাম্বারটা আছে is set aside. The land manager, respondent number 4, land manager rankটা বলে দিই Bidhannagar, Urban Development and Municipal Affairs, Government of West Bengal, respondent number 4 is directed to remove the signboard affixed on the plot number such and such, demise to the petitioner. Further, the land manager, respondent number 3, is directed to consider the representation. When was the first representation made?
My lord, the first representation was made on
Consider the
13th
representation of the petitioner
30th of November 2016, my lord.
dated
Case
30th November
2016, my lord.
Where is which page?
Case 34 of the writ petition, my lord. Annexure P5.
30th November 2016, 22nd December 2016. This was addressed to the special secretary. Who will consider?
All the three. My lord, we had issued representations to each and every of the respondent, my lord.
All will not consider. No? Somebody has to consider. Who will? Land manager. 4. আচ্ছা কি বললাম ডেটটা? না 29th December, না 22nd December এটা বলেছি? 16, 17 January 2017, 18 January, 16th March 2017, এতগুলো ডেট না দিয়ে না from 16 to 19 con. All the representations made by the petitioners for extension of time period to complete construction made between November 2016 till which was the last one, January January 2019. Within a period of 4 weeks from date of receipt of this order, by affording opportunity of hearing to the petitioner and pass a reasoned order in accordance with law. Learned advocate for the petitioner is directed to, will it be required or you communicate this order? Communication take 4 weeks, so learned advocate learned advocate petitioner directed to communicate this order to the land manager, respond number 4. With the aforesaid observation, writ petition stands disposed of.
Much obliged, my lord. Your lordship, in item number 9, learned advocate.
Item number 9.
But I'm for the private response.
Learned advocate for the petitioner is out of station, your lordship. Ram Guchais. May I humbly pray it may be kept on Monday, your lordship.
So this substantially been, my lord, heard by your lordship, my lord, almost on the being over, my lord, on the verge of being over.
Monday.
Monday, your
Monday the post going. And also bring that act. He was
Yes,
Mr.
I've got a copy, my lord.
Mr. Roy was
Yes, my lord, he was arguing
177.
177.1. The scope of, my lord, regularization.
Then you cooperate with that. If the HMC finds it that it is a illegal construction, then respondents will cooperate for removing. If it is a new structure, then it can be removed.
It can be removed, but at least that the respondent should come forward because the morning that I said, let it be so. Actually, what is the difficulty for the respondent regarding remaining of that portions of the
On Monday.
My lord, for 20 square feet, my lord, is the unauthorized construction.
So you cooperate. Mr. Roy said that if it is not an old temple and there is no idol,
That is an old building, my lord. The construction is because in 1958, my lord, a deed, my lord, that is mentioned. The construction.
1958.
58 deed.
No.
And secondly, my lord, regularization, scope of regularization is there in the
If it is a new construction,
and thirdly, my lord, already, my lord, application for praying for regularization that was made to the corporation back in, my lord, 2023 September. That is also, my lord, kept pending.
no, they have submitted the report that it is
20 square feet of, my lord, temple.
no. Either you cooperate or I will pass an order. You cooperate with that. If it is an illegal construction and no idol is there, they can remove it. You cooperate with them.
No, my lord, idol was there. That is what fell from your lordship. Since, my lord, regular, my lord, worship is going on in that temple.
No. He said that the construction has been undertaken.
That we have very report regarding that. Subsequently, my lord has directed that a reservoir will go there.
No, they are not in the event of depositing that amount.
Then that is their fault.
Petitions.
Now, in the meantime, they came up and they say that they are.
They should have to agree with our reports.
Then respondent has to cooperate with Howrah Municipal Corporation for removal. They say that it is a illegal construction.
Well, what fell from your lordship, my lord, from on the previous occasion, my lord, that the special officer will go there for the purpose, my lord, that whether, my lord, it's a new construction or an age-old construction, my lord, so far as the, my lord, the temple is concerned, which is, my lord, on 20 square feet of land. Now, my lord, the difficulty is, my lord, it was, my lord, the petitioner's, my lord, obligation, my lord, to pay the amount. They refused. My lord,
Yes.
that is the difficulty, my lord. Well, now, my lord,
The temple person this temple is also unauthorized, unfit.
Otherwise, my lord, everything has been, my lord, already been removed. My lord. Everything is gone.
No, you're not correct. Para 11 of the report speaks that it is a unauthorized construction.
Yes, my lord, my lord, admittedly.
There cannot be any
20 square feet.
Mr. Banerjee, there cannot be any idol in an unconstructed temple. Indeed, Monday.
obliged, your lordship.
You cooperate with him. It is to be removed, it will be removed. You cooperate with the Howrah Municipal Court on Monday.
But, 13 days they will come with the proposal that what they will.
Yes.
It can be recorded in the order.
On Monday, I will see. Monday, finally.
Item number 10.
I am for the petitioner, my lord. My lord, what happened, my lord? Earlier occasions, Honorable Justice Kafur Bench, the order dated 25 June 2024, that is
Illegal demolition.
kindly come to
Yeah,
that
proceed,
order,
sir.
my lord, first.
Duly paid to the presidency. It is further submitted that the proceeding under the basement. Right. Without any rights and countries of parties. Okay. Same as attend finally. Who is for the state?
State Mr.
Mr. Dey.
Dey, my lord.
They say that the proceedings under Highways Act has been initiated. Your grievance is that it has not been removed as yet.
Oh, my lord, one thing is that this is a very bad practice in the highway. The land has not yet been encroached by me. Even that the land is not in possessions of the highway. Number one. Number two, they have forcibly demolished my four-story constructed building, which is come now at the rate of rupees 5 crores till today. Now, what happened? My lord, the entire property, which is still in my possession.
Because the directive.
So the state cannot go even an inch that the land has been acquired by the state.
So this was released. Why this was released?
Yes, my lord.
This has been released.
No, the state has not yet been returned to my land. Even the demolitions by the highway, legal demolition, arbitrarily, no compensation. I am a residential house. Everything
if you
is in right way.
what residential? If you encroach into the land of the private, the highways authority, then they will not remove you.
No, my lord, higher authority has gotten I have gotten encroached any land from the highway authority. Highway authority, my lord, kindly come by only the my lord thought.
David will clear the authority.
Notes, my lord, I am giving all details.
According to section 8 of the encroachment. What is your plot number?
Yes, my lord.
What is your plot number?
My plot number is 237, my lord.
237. Give a notice to Mr. Dey. Mr. Dey is appearing for the state. Give a note. Asun.
My lord, one thing
appears
is
on
that,
behalf
my
of the
lord,
state.
my lord, let me allow to submit, my lord. The case is running, they are absent every day, my lord, so that kindly allow at
Give a
least
notice.
the mandatory notice issued to the Mr. Dey. If he will not appear, the matter will be hard expert.
Release করে দিয়েছে না? রাইস ওখানে রিলিজ করবি। None appears on behalf of the state. Learned advocate for the petitioner is directed to serve notice upon Mr. Chundi Charan De, learned advocate for the state respondents, intimating him of the next date of hearing. List this matter on 15 দিন পর ডেট বলুন যেখানে হিয়ারিং হতে পারে। হ্যাঁ মানে যাবে হিয়ারিংটা হতে পারে। #21 January. Next.
January.
Item number 11,
As number 11 is concerned, would it be your lordship?
11 and
present?
12.
Respondent, your lordship. Respondent state. The state had almost completed its argument. The lordship present to keep it on 15th or 22nd, your lordship. Because the petition is also not present.
None appears on behalf of the petitioners in the read petitions. Your respond number? Learned advocate for respond number 5
State, your lordship.
in WPA 20293 of 20.
Analogous.
Ah.
But I am
You are for?
12. These are analogous.
Learned advocate for the state respondents in WPA 20293 of 2023 and WPA 27298 of 2022 submits for fixing a date after 15th.
15th or 22nd, lordship, whatever. 22nd should be better, lordship.
Date for hearing. Please this matters on 20.
22nd.
20.
22nd, lordship. 22nd.
22nd. Ibar. Second of it. No, 23rd করো না 20 ওহো 22nd দেওয়া था করে নিন আপনারা বুঝলেন কেটে নিন ঠিক কেটে নিয়েছেন আচ্ছা একটু বিকেলে আসবেন চেম্বার কারা কারা যাবে আমি একটু দেখে নিয়ে তো লাগবে না কোর্ট অফিসে তো লাগবে না দেখি পঙ্কজবাবু যায় নাহলে আমাদের এখান থেকে নিতে হবে ফাইনাল করে নিয়ে ডেকে যাবে ডেকে মিঠুনকে নিয়ে নেবে কজন যেতে পারে রাত বেশি তুই সেই যদি আবার কোনো অ্যালাউন্স না পাই তাকে নিয়ে গিয়ে কি করবো 4 জন যেতে পারে স্বামী যাবে আর 3 জন এরা পঙ্কজবাবুকে নিয়ে নিই মিঠুন অরিজিনাল সাথে পঙ্কজবাবুকে ঠিক আছে আসলে
Item number 13,
My lord, I am for the
13.
petitioner.
Your lordship, in this matter, Mr. Shivashankar Banerjee and Syed Nurul Arifin is appearing, your lordship. 5-10 minutes.
It's already 1 p.m. Almost 1 p.m. Then fixed it on another day, my lord.
tomorrow
Tomorrow, yes. Tomorrow.
no, not today the hearing
So
is
almost 1. Tomorrow. I'm prepared.
not today tomorrow you'll argue
Let's see.
Item number 14.
My lord, I am for the private respondents, my lord. I'm praying to make it not today, my lord.
Right. Who is for the petitioner?
I am for the
What is the case? Oh, where is Mr. Dhar?
Mr. Dhar has instructed me to pray for not today.
কালকে report. It is you. And you are for? You have made your payment. The only dispute is regard to apportionment. ठीक है কালকে করব tomorrow.
Item number 15.
देखो report in the form of any finance will be taken on report. কে অ্যাপিল করেছে কত নম্বর দিলে 15 1222 হ্যাঁ হ্যাঁ ঠিক আছে রূপপুরি কালকে দেখুন not today not today.
Item number 16.
Suji Talukdar is appearing on behalf of KMDA, my lord. Honest,
Yes, yes. Sir, this repetition is directed against the demand notice issued by the Kolkata Metropolitan Development Authority for mutating the names of the petitioners who got the leasehold property on the basis of will which has been probated by this honorable court. With a cancel letter of demand. Now kindly come to demanding notice 6 for mutation proceeding question. Why this amount is towards tax, unpaid tax?
No,
Then
for the purpose of mutation. Only for the purpose of mutation.
under which provision this amount has been calculated?
There nothing has been indicated.
Where is the notice?
Lord, your lordship kindly come to.
my lord, one indulgence, my lord. Mr. Talukdar is engaged in courtroom number 2, my lord. I'm praying for not today, lordship.
2.
1 days ago. Will not be able to come, my lord.
Lord, kindly come to page 113. Service charges, Lord. 5,29,148. Property was leased out in a consideration of 47,000 only.
This lease is transferable. I mean, the lease can be sublet to other person.
But here, it is not at all a transfer. By will, the property was bequeathed to the the legatees, and the will was probated by this honorable court in its original jurisdiction. And thereafter, the beneficiaries of the lease will, they applied for mutation. That our names should be mutated instead of the original lessee. Lord, and for such purpose, they applied for. And Lord, your Lordship kindly see all the documents are placed, and ultimately,
just ওই হাওড়ার কেসটা কবে রাখলাম মানডেতে কালকে রাখো হবে কেন কি থাকে this is the only grievance that they cannot raise this amount.
No, Lord, they are not at all. And it has been held by this honorable court in earlier cases also.
Okay, tomorrow কালকে রাখো ask him to remain present tomorrow. Just that point there, whether this is a legal demand or not. If the provision so says that the subsequent persons who have applied for, after getting the probate, they have to make payment, then it's all right. He has no case. But if there is no provision, then we have to examine that one. Tomorrow.
Item number 17.
My lord, in this matter, I am appearing on behalf of the petitioner, my lord. On last occasion, my lord, my learned friend has submitted a report before your lordship. My lord, on perusing the report, my lord, it is clear, it has been clear, my lord, that the award has been declared in favor of the son of the landowner. But, my lord, the landowner has, Murat Mullik has, my lord, executed one will, and on that we have been, and my lord, a will, and in the will, my lord, his grandson, he has given that property to his grandsons, and the record has already been in the name of the grandson. So, my lord, I want to bring it.
Disclose.
No, I want to.
Petition, my lord.
My lord,
Because the primary question was, my lord, whether the award has been paid to the petitioners or not. Erstwhile owners of the petitioners or not. We have submitted, my lord, a report on behalf of the, my lord, competent authority under the Railway Amendment Act 2008, which is, my lord, additional district magistrate. Kindly see, my lord, report dated 20th November 2024, where it is stated, my lord, we have declared the award, we have invited them to take the award, but they have voluntarily refused to take the award.
no, my lord,
Now,
that is
now
not
the award
correct,
is
my lord.
lying with the
That is not
authority.
correct.
We are ready to disburse
My lord,
in accordance with law.
that is why, my lord, I want to bring your lordship notice, my lord. That no, nothing, sir. I'm not nothing submitting, my lord. The will has been executed, my lord. The probate has been declared, my lord. The land,
My lord, that's all nothing.
Structure of petition.
My lord, the record has already been in the name of the grandsons, my lord. So I want to bring your lordship's notice, my lord, the name of the grandsons, and thereafter your lordship dispose of the matter. Only 1 week time pending. Then when the retribution has been filed, we are not aware about this proceeding, my lord.
Explosive.
No.
We are stage, my lord. Kindly
This is
consider.
because, my lord, is not.
Substantive hearing, my lord, they are coming.
We were not aware, my lord, that this.
Fact that is within their knowledge.
No. That was not knowledge of ours.
I am ready to your mind.
Can you give me 1 week time, my lord? I shall submit, my lord.
You will receive the amount.
My lord?
You will receive the amount which is lying.
No. I have not.
Then what is your submission?
My lord, my submission is the award is that the award has been declared in favor of the sons of the landowner, my lord. Now my submission is, my lord, they are not entitled to get the amount because the landowner has executed one will, and on the basis of the will, my lord, his grandsons are entitled to get the amount, my lord. I want to bring your lordship's notice, my lord, the document before your lordship that the grandsons are entitled to get, my lord.
Then the writ petition is not at all maintainable at the instance of these parties. Withdraw this writ petition and let the grandson come up before the court and say that they have not received.
My lord, one thing, my lord, kindly.
No, dismiss the writ petition.
No, my lord, not today, my lord. I am praying for not today, my lord. My lord, I have one.
Record your submission and dismiss the writ
No, my lord,
petition.
not today.
Now you are coming up after hearing.
My lord. My lord,
2
kindly
days
fix
we
a
have
date.
heard this.
Fix one date, my lord. Fix a date, my lord. I shall produce document before you.
What will be the fate of that document? The court has to hold that the
My lord, they
petitioners are not entitled. So dismiss this writ petition
My lord,
and go to the appropriate authority and claim that this probate has been granted in your favor. Let them disburse the.
Liberty may be granted, my lord.
my lord, I shall claim, my lord, I shall
Maybe,
claim.
my lord, place.
I shall claim that. But I
When was
want
the
to-
probate granted? Let me find out. When was the probate granted?
My lord, that I want to,
You just tell me the date. It is a writ petition of 2023.
yes, my lord.
When was the probate granted after
My
this?
lord, one prayer I have before your worship. When
When was the probate granted?
my lord, one thing, my lord. Uh-huh.
Then
My lord,
you have not.
my lord, kindly, my lord,
Madam, what will be the fate of the writ petition?
my lord, kindly.
If the writ
kindly-
petitioners are not entitled to, what is your claim? Your claim is that the compensation has not been paid.
No.
Now you say that a probate has been granted in favor of the
My lord, kindly
grandsons.
sit down, my
They
lord.
are entitled to that. Then how come the writ petitioners are entitled
My
to
lord,
have
one
this
thing,
writ petition?
my lord, one prayer, my lord.
Orders in
When-
terms of the.
When I have, my lord, kindly see the prayer of my petition, my lord. The prayer of was, my lord, that they have acquired land and there's some portion of land and they have disbursed the amount. We have nothing, my lord. And subsequently, well, that we came to know that they are encroaching our land. We have filed this, my lord. Kindly declare them or ask to declare our compensation. My lord, when we have filed the writ petition, my lord, my learned friend has appeared in the matter matter and filed one application for additional party. From that, we came to know, my lord, regarding this proceeding, my lord. This proceeding.
You have stated in the process.
Yes, my lord.
I'll come
Yes.
on with that, madam.
My lord, kindly fix a date, my lord, another
But,
date, my lord.
there were
for
two acquisitions done, madam,
Yes.
in
Second,
2012 and 13, madam.
first acquisition, we are not allowed,
Thereafter,
madam.
one acquisition was done out in 2019 and 20. Notification came in, my lord. In that, my lord, the award was been fixed up in 2015, where the award was there. So they did not turn up into this. This was not the writ petition that they have come up with. They came out with that. What the notification in 19 and 20 that came up, that was the dark was 1878 dark number was there. In that we acquired was 3.45. That was the decimal we acquired. Before in 2012 and 13, my lord, that was acquired was 2.2. So there, that was been a chapter not been taken in. That land, that at that time, my lord, actually the land belonged to the Sambhunath Konar, my lord. And Sambhunath Konar's sons were there in the first acquisition in 1213.
3.45. 3.45 is the first one.
That was 3.45 was the second acquisition.
Okay. This has been paid.
That has been paid, my lord.
So there
I
is
wrote all
no
the documents.
there is no dispute with regard to
My-
3.45.
And regard to that dispute also, that was brought out for the first time when we came out with a clear picture what was the actual story into this. So they never came out in this writ petition. They never even written anything in regard to that. And they started with this in the writ petition. They started with the story, what they set out. In 43, we got the acquired the land. My grandfathers, forefathers got the land. And in 2021, first time they made out the application before the BLRO for the correction of record. Thereafter, they written down one acquisition took place. In that, the acquisition, they got the amount. Now, what the chapter they came out in the prayer was that to restore or release the land which has been illegally occupied. But that was never been illegally occupied, madam. So your lordship told me into that to bring out the exact total details, what was the amount was been paid. So I gave out the entire details into that. Even I gave out the details of 2012 and 13 also. What was the award? At that time, there were 10 co-sharers. But this time, the petitioners there, the grandson means the son's son. Forefather was Sambhunath. Thereafter, his sons came in, the 10 co-sharers in the first acquisition. Thereafter, these 10 co-sharers, their sons are also there, means grandsons. So in
So
that,
let the appropriate authority at the time of competent authority at the time of disbursement assess who is entitled to what portion?
The competent authority, they did not approach to the competent authority.
My lord, we are unaware about that, my lord.
Even that was
If we are
publication
ever-
was done in the newspaper also. in
No,
regard.
my lord, we are unaware about that. This is our case, my lord. Regarding the first acquisition, we are unaware.
0.24.
First time we came to know, my lord, the affidavit filed by my learned friend. My lord, kindly see the probate.
So you go and collect your compensation.
My lord.
They say that the amount has been deposited with the authority. You approach the authority is granted liberty to assess what share will be given to the petitioners. If they are not entitled, they will not get that.
My lord, they are entitled because probate has is there money in favor of them, and land has already been recorded in their name, my lord. Already kindly see, my lord. This is they are recorded in their name, my lord. 3.63. That is why, my lord, I want to produce those documents before His Lordship. Your Lordship dispose of the matter.
My lord, that has to be
Otherwise,
decided by the competent authority because the
I
amount
know
is
that-
already there
Yes.
since long, my lord. If they don't go and approach the authority, how could the authority pay them?
My lord, we shall go.
My lord, in accordance with law. after
My lord,
verification
can a read court
Yes.
come into this fact also ki what the payment has to be
We are
done?
ready to
They
discuss.
have to go before the authority to
Yes.
push themselves, my lord.
Yes. We are ready to discuss. That is my view.
Okay.
My lord, kindly give me, my lord, 7 step. I want to, my lord, produce the document before Your Lordship dispose of the matter. Directing the authority. Well, otherwise it will be complicated. It may be, they may arise, my lord, you have not told it before the honorable court. That is why, my lord.
Why didn't you state before the court that there is a private proceedings?
My lord, first time we came to know regarding this, my lord. First time, say, regarding the first, regarding.
You have stated so many facts and you have just could not get hold of that probate.
I'll consider this.
My lord, for the first time,
Since the amount has been since the amount has been deposited, liberty is granted to you to approach the authority to have the compensation released in your favor. This can be made. And they will act in accordance with law and find out how much share is there with the petitioners.
My lord, but they have declared the award in favor of. They are not entitled to get, my lord, according to the probate proceeding. But we are not aware about this proceeding, my lord. How could I know? How we were not aware about this award, my lord, for the first proceeding. We are not aware. If we are aware, my lord, we shall put all documents before Your Lordship at the time of filing the.
In this writ petition, you cannot challenge the award on behalf of the persons in whose favor the probate has been granted. Then you have to say that the petitioners are not entitled, the grandsons are entitled. Then the writ petition is not maintainable, it will go.
But my lord, they challenge on the second acquisition. That is already been paid.
No, not
So
second. We have not challenged.
Yes,
the
my lord,
second.
that is only there.
No. I have
My lord,
said
kindly,
no,
I can
I
show
have
the
not.
writ petition also.
No, I have not challenged, my lord. It is a admitted fact. It is admitted fact.
Who was appearing? Your senior was appearing. He made a submission before the court that compensation in respect of 0345 has already been
Kindly
paid.
take the page number, my lord, 6 of the writ petition.
Yes, my lord. My lord, kindly take the matter.
Where it was noticed?
Para number 5, my lord.
Yes.
It is stated that in the notification number 1706 dated 18 June 2020, the acquisition of land was noticed as 3.45 middle portion, but the railway authority acquired the whole plot 4.33 decimal, and they have constructed road by filling the ponds with soil. This road has been constructed on non-acquisition land. The petitioner protested for such illegal work, but the respondent concerned did not pay any heed. The petitioner also sent letter to the officer in charge, Calcutta Police Station 16/5/2020, treating it as a GD. Thereafter, in the 6th, they say they got the payment back. It is stated that the notice was issued on 21/2/2022 by the competent authority to the co-sharer, asking them to accept the award as declared under 20F 120F3 of the Railway Amendment Act 2008 regarding acquisition land. The co-sharer have accepted the award on protest. There was nothing to show what the protest was there. They never made a letter to that. And even if I go into the prayer also, my lord, it starts at page number 10, my lord. What they have asking, my lord? The writ in the nature of mandamus commanding the respondent to restore at page number 10, my lord, release the illegal occupied land of the petitioner except the notified land. So the notification was of 2020, my lord.
So that was never 2012 and 13 with a notification which was there, they never came out into that. Even in the writ petition, the power of attorney that has been given, in that also some of the co-sharers which they have written in the petitioner as a power of attorney, they were also a part in 2012 and 13. So if they say they are not aware to that, it is very unfortunate.
No, Malon, we are not aware regarding the first acquisition proceeding.
So restoration of which land? 0.345.
Yeah, man. Because only this is the story they written into the writ petition, my lord. Apart from that, the acquisition that took place in 12 and 13, they
Not
never said they
0.35,
suppressed the
my
entire
lord.
thing, my lord.
4.33 was the whole land, Malon. Malon, can you take it a
And
more
even the
forward?
land acquisition, if I say, my lord, they start out in 2021. For first time, they went to the BLRO for a correction of record. That is in page number 5, my lord. They have written in para number 3, my lord. He stated himself that the learned advocate has filed his representation to the Block and Land Reforms Officer, Kanska, Police Pashchim Bardwan, and the DLLR to correct the record of rights. The total portion of land measuring is 4.33. That is also wrong, my lord. If I take into 2.15 and 3.45, that goes up more than decimal 5. That even in the paragraph now where they start out with second paragraph, after locus standi, they say they bought a land of 4.33. They're
Total land was
sufficient. But
4.33.
actually we acquired more than that, my lord. That was 5 point something 35, my lord. So that we acquired from them. Even not 4.33, my lord. Even their submission, the writ petition is there. In 43, the grandfathers bought a land which was measuring around 4.33 decimal. That is also incorrect, my lord. If I say, I gave out a purchase also, my lord. Here it is, my lord.
In your affidavit?
Well, I had given this before also, my lord, before at the time of when I placed out my submission, my lord. There are two part of land, my lord. It can be shown. One is already been the first part, my lord. Bharat Sarkar, my lord, 2315 cc. That is 0.22. Actually, it was 2.15, my lord. And thereafter, the bottom, my lord, 3155, that is 0.35. 345 was been done, my lord. So, before it was 2012 and 13, the acquisition took place. We gave out in our opposition also the entire details of the award which was been done. In 2016, we deposited the check also on behalf of the people who had been allotted as an awardee. That was done by the competent authority. We deposited the entire amount, my lord. My lord, I placed out this document also. I hope out this document is there, your lordship. This is the report where I have given the entire details of amount.
এদিকে টপে রেখে দেবো কবে যাবে দেখো তো টপে একটা
It is a competent authority to decide now, madam.
Look, Mr. Solan, advocate seeks accommodation. 8 January. Eighth has been. Submits that the grandson of
My lord, the grandson of the landowner, my lord.
March. If a probate has been granted in favor of the grandsons of the landowner, the Konars, they are the landowners.
Yes, my lord.
Konars, this Jyotirmoy Konar, they are the landowners.
My lord, before
Jyotirmoy Kona's son now is
Jyotirmoy
son, both
Konar, in
together.
the first
Jyotirmoy
acquisition
Kona's
that took
son
place,
is
my
now-
lord, he was one of the awardee. That was a check was been issued into 10 co-sharers. One of the co-sharers was Jyotirmoy
Oh.
Konar. In the second acquisition, my lord, it is his son, Abhijit Konar.
In this matter
But
also.
Abhijit Konar never gave out a power of attorney, but still also he filed up this petition.
Now, this is not a case of subsequent transfer. This is a case after the compensation has been received, a probate at will has been executed.
Hello, will has been no.
Yes. And got it probated. And then made an application for mutation. Change in the records. What I assess.
I was able to understand.
Because how the probate is coming into picture is he could not transfer. So he was advised to execute a will, made a will. After will, the grandsons come into the picture.
But even if I say 2016, when the checks were given, when the publication was done out by the state government to receive the award, they could have approached, even if that was a fact, they could have approached, but that they did not do into that.
But then
He came to know the filing.
you satisfy the court how your prayer will be considered in the present writ petition because submits that probate has been granted in favor of the grandson of the landowners who are entitled to get compensation. She seeks to produce documents. List this matter on top. 21st top 21st আর কি আছে yes top top pending হয়ে যাচ্ছে please try to make your submissions whatever there is in record whatever you like to submit then he makes his submissions then again you take up another ground that makes a thing difficult.
Everything I have stated in my.
Once the compensation has been deposited you go and approach the competent authority. Let her come up with the documents. Let's see.
I shall go, Mala. That I shall go. But I want to record the names of the
Kagaz
grandson. That is documents I want to file before the.
Okay, thank you, sir.
শুক্রবারের নামটা দিলাম না তো। আচ্ছা, you will know, but he isn't it?
আমি তো ওই গ্রাউন্ডে অ্যাটেন্ডেন্স চাইছি
Adjournment চাই।
আমি একটা প্রধান যে পড়া তোমাদের
ফাইল করতে চাইছি একটা সাপ্লিমেন্টারি এফিডেভিটের ডকুমেন্ট গুলো কোর্টে দেবো বাস তারপর ওখানে পাঠিয়ে দিলাম ওখানে গিয়ে করবো
15 তারিখ
এখানে না দিলে তো পরবর্তীকালে কমপ্লিকেটেড হয়ে গেছে হাইকোর্টে বলো নিয়ে সব সত্য ব্যাপার
তারিখে একটা দেখলাম ডিপার্টমেন্টে আছে কিন্তু এটা না কালকে রিপ্রেজেন্ট খুব বোরিং এসে পড়ে
এটা হবে না
না সব লিখেছি
ওই তিনটে হ্যাঁ ওটা তখন
কি বলছো দেখি দিতে বলুন
Lordship, I'm praying for
Their number of shares is the number of shares is 45 shares.
অর্ডারটা কে দিয়েছে Where is the order?
We are it.
চাইছি
শুধু আমরা পিটিশন অ্যাপ্লিকেশনই থাকে
দেখে নিয়ে চাইছি আচ্ছা মাসের সমস্যা দেখুন
দিতে পারছি
দেখে নিয়ে দেখে নিন। Yes.
Lordship, I'm praying for leave to be granted for to drop and complete the order dated 3rd
Yes.
July 2024.
My lord, may I be permitted to mention one matter? First, correction. I've intimated all the parties are here.
Lord, I'll just indicate, my lord. The first one, my lord, I wish my lordship a very happy new year.
Okay, same
Lord,
to you, sir.
what has happened, my lord? In the order dated, I'll just take a copy. In the order dated, my lord, 10th of December, there is a small error, my lord. The line was going like this: with the report of the registrar is circulated amongst the parties as well as the special officer. Well, it would be recirculated.
Oh,
That is why, my lord, I'm not getting the copies of the order. And my lord, one more thing, my lord, the special officer who have been appointed in this bar association room number has been written as 5, it would be 9. The supplementary list.
inadvertent typographical error has crept into order dated 10th December 2024 in
SLOD করে দিন। ODS
second line of the first page. To the extent that the report of the registrar be circulated amongst the party as well as the officer, special officer, instead of the report of the registrar is circulated. একই ওটা ইনভার্টেড কমার মধ্যে রাখবেন সেন্টেন্সটা
by the registrar, my lord.
হ্যাঁ হ্যাঁ শেষে বলবেন by the registrar. The report of the registrar be circulated amongst the parties as well as the special officer by the registrar original say. দাঁড়ান দাঁড়ান Was any report circulated the
No.
7th December?
No, my lord.
Never.
I thought no report had been served. That was the date when the report was filed before this.
আপনি কি জিজ্ঞেস করছেন? ফার্স্টে বলবেন যে সেকেন্ড লাইনে ইনভার্টেড কমার মধ্যে the report of the registrar is circulated amongst ওটা বি বললাম তো be circulated amongst the parties as well as the special officer by the registrar original site instead of sentence words report of the registrar is circulated amongst the parties as well as special officer.
Second page, my lord, at the bottom there is have been indicated. Bar association room number 9.
1, 2, 3, 4. Further, in the fourth paragraph, in the third line, the bar association room number should be 9, inverted comma 9 instead of 5. The other portions of the order shall remain unaltered. The- in. থাকুক।
Original site daily list, item number 1.
My lord will recall this is that sale of Lenin Sarani premises. My lord, the special officer, my lord, has
Special officer, my lord, I had received a bid, my lord, on the last day, which I was to incorporate in the report. I've incorporated that, and the bid, my lord, demand draft is there in this with this.
Where is the report?
May I file the report? The last page, annexure F, is the photocopy of the demand draft that I had received. The original is with me. That is the only bid that I have received pursuant to the advertisement.
$45 lakhs is the reserve price.
But the reserve,
no, but it is 3 crores.
the earnest money.
Earnest money.
Yes.
Who is this person?
I have refers, my lord, I have sought for extension of time with my bid. Lordship was pleased on that extension. Pursuant to that, my lord,
Okay. So the sale has to be confirmed in favor of Lenin projects.
Whoever has come, my lord, there's no further bidders. As I said to your lordship, my lord, even on the last occasion, 6 or 5 times this has been advertised. Nobody really came forward. One Mr. Banka came forward,
He
but as
didn't
your
pay.
lordship has seen, he has been unable to pay. That's why we are before your lordships. And my lord, the valuation report is also there, which shows, my lord, roughly the valuation of 2 crore 90. Page 121 shows 2 crore 99 lakhs. And their offer is, I believe, what the offer কত দিয়েছে তুমি? 3 crore 10 lakhs. So it is also, my lord, above the 112 kindly considers it is above the, my lord, valuation that the valuer has, my lord, arrived at.
All the three properties are 2 crore 99 lakhs.
All three together, it's really contiguous, my lord.
And they have offered the price at rupees?
3.10 crores.
Okay. আসুন।
Lordship's last order succinctly, my lord, records the entire gamut of the dispute, my lord. The Lordship's order of, my lord, 18 November.
supplementary report filed by the special officer is taken on record. Mr. Saurajit Dasgupta, learned special officer, submits that pursuant to the publication, paper publication, only single bid has been received. And the earnest money of rupees 45 lakhs has been delivered by way of a demand draft. Mr. This is an application seeking leave/permission to sell, convey, and/or transfer the properties comprised within premises number 116 Lenin Sarani, 117 Lenin Sarani, and 117/1 Lenin Sarani, PS Muchipara, Kolkata 700013. Mr. Rupak Ghosh, learned advocate appearing on behalf of the petitioner, submits that the previously the sale in respect of premises number 117 Lenin Sarani was confirmed in favor of Mr. Bikash Banka, but since no further payment was made, the sale could not be executed. The present bidder has offered a price of rupees 3.10 crore, which is well above the valuation of all the three properties taken together to the tune of rupees 2,99,24,000. He seeks for sale of the aforesaid three properties in favor of Messrs. Lenin Projects LLP or its nominee. This amount will be deposited within which time?
Within, my lord,
4 to 6 weeks, man. I pray for 6 weeks, my lord.
Okay. Learned advocate representing Messrs. Lenin Projects LLP informs the court that the rest of the consideration amount would be paid within 6 weeks. In view of such submissions, leave/permission is given to the applicant to sell, convey.
At this juncture, may I interrupt your lordship once? Kindly come to page 74 once. It's the applicant's real, my lord, PAN number. My lord knows, my lord, these trusts are very old. But the PAN number and the actual name sometimes differs. Page 74 is the PAN name with which the trust is registered. So the entity will be this, my lord. Shri Shri Ishwar Sridhar Ji Devottar Estate.
The leave/permission is granted to the trust, namely Sri Sri Ishwar Sridhar Ji, to sell, convey, and transfer.
Sridhar Ji Devottar Estate. That is a full name. Page 74.
বানানটা দেখে নেবেন।
I'm writing it separately.
ওই বানানটা ওখান থেকে দেখে নেবেন। শ্রী বানানটা কি হবে, দেবোত্তর স্টেট বানানটা দেখে নেবেন। premises number 116 Lenin Sarani, 117 Lenin Sarani, 117 by 1 Lenin Sarani, PS Muchipara, Kolkata 70013, at the offered price of rupees 3.10 crores upon payment of consideration within the stipulated period as aforementioned. Upon completion of such transfer, a report shall be placed before this court by the learned special officer. Within, after payment, how many days it will take to execute the deed?
Within 2 weeks, thereafter.
Within 2 weeks. Convey within a period, the registration shall be concluded within a period of 2 weeks. Release this matter after 8 weeks. 6 weeks for,
Since, my lord, it will be registered, my lord, within 2 weeks, the market value be deemed to be, my lord, the valuation, the consideration value, my lord, for
Since
the
well, it's a
purpose of
court
stamp
sale,
duty.
since
Yes.
in these matters, it's a court sale, and court is well, no less than the High Court is monitoring the sale. Well, this sale amount here should be taken to be the market value of the property, and no further inquiry should be made by the stamp collector.
okay, it is more than that.
We do not know what they will do. If that is not done, they will individually assess a market value and levy stamp duty on that. That should not be, because the honorable court is in session over the matter, and pursuant to a public auction in a court sale, this price has arrived. This should be the market value.
Okay, then what about the stamp duty will be paid on this amount?
On this amount. On this amount. And that is the general order that your lordships make, my lord.
Offered amount of rupees 3.10 crore should be accepted as the market value.
For the purpose of stamp duty.
For the purpose of stamp duty.
Well, maybe handed out.
Yes. The demand draft, what is the number? The number to near.
Number is valid. 02 021651.
Drawn on?
Drawn on, my lord, Axis Bank Limited.
Axis Bank, dated?
Dated, my lord, 18 December 2024.
Is handed over to the learned advocate or the applicant.
So deeply obliged.
My lord, only one more prayer.
After 8 weeks. Yes.
Leave to file my wakalatnama in the department, my lord.
Leave is granted. Leave was not granted earlier.
My lord,
leave is granted to the respondent Lenin, Mrs. Lenin.
No, not respondent, my lord, successful bidder.
Leave is granted to the successful bidder to file wakalatnama in the department.
Item number 2.
My lord, in item number 2, I am appearing for the petitioner. This application relates to the Everest House building. It's a. I'm for the defendant number 10, new the owners application. association. It's in respect of a different unit. My lord, praying for prayer C, my lord, for carrying out the paper publication. My lord, similar kind of order was passed by my lord in a different application of similar nature, which appears in page number 140, 137 and 139.
Who is the applicant here?
The applicant is one
intervener.
My lord, intervener, not a party to the main suit.
This is an application for execution of deed of conveyance in favor of applicant intervener in respect of office flat number 20C, capital C, along with a pantry and toilet situated on the 20th floor of Everest House at 46C Jawaharlal Nehru Road, Kolkata 70071. In favor of applicant's nominee, namely Uniworth Vanijya Private Limited. Mr. Ritik Chaudhary, learned advocate appearing for applicant intervener, submits that you have paid the entire amount,
My lord, enter.
that the applicant has already paid the entire consideration amount. However, the deed of conveyance has not yet been executed in favor of the applicant. Stop. He seeks for an order for publication of the substance of the application and the prayer No, এখানে অন্য আছে. He seeks for an order for publication indicating a publication once in English daily and once in vernacular daily, indicating the conveyance sought to be executed in respect of flat number 20C, along with one pantry and toilet and gist of prayer. In view of such submissions, let there be order in terms of prayer C of the notice of motion. A draft notice shall be approved by the learned registrar original side prior to publication. List this matter after on go the 2 weeks for it. After 2 weeks. Date to 2 weeks.
Much obliged, ma'am. However, the affidavit of service will be approved.
Put copy দিয়ে দিন affidavit.
Item number 3.
Item 3 is my application, my lord.
There is two application, my lord. One is my application. I'm applying for the plaintiff petitioner.
My lord, before my learned senior friend starts, my lord, I'm being led by Mr. Subhashi Sengupta, my lord. He's in some personal difficulty today. He's not been able to come back to court, my lord. We'll kindly adjourn it for the week, my lord.
Which is your application? 3?
A16, that is that is item number 3. That's my intervening application, my lord. I'm seeking to intervene in this suit filed by the plaintiff.
Okay.
My application is 17, my lord. I'm seeking for appointment of an advocate commissioner for recording evidence, my lord. My lord, this application is, my lord, I'm opposing this. Apparently, the intervener is a beneficiary of a will.
Okay.
They're saying the testator have some interest to one of the properties of this partition suit. This is 2010 suit now. It's an undefended suit. The testator actually filed an intervening application before. That's been dismissed for default. Now they say the testator has been made a will to this intervener. And how can this maintainable when he's a beneficiary?
Can be imputed as a party defendant.
In a probate application, they filed.
But my case is
Basically,
perhaps not that. my lord,
They
it's
have
my
filed. Opposition has been filed.
No, my lord can issue directions for affidavits, my lord, if required, or my
You
lord
have
before
served.
that. Yes, my lord, we served. But my lord, two issues, my lord. We are not in possession of two documents in the suit. We are not in possession of the plaint. We have written to the advocate on record for the plaintiff also for a copy of the plaint. We are not in possession of the plaint. And we are not in possession of, my lord, the application that my learned senior friend is seeking to move. That is item number 4. So, my lord, if directions can be passed, my lord,
No.
for them to serve a copy of the plaint and the
First 16 will be decided.
My lord.
If you succeed in getting implicated in the party, then the question of serving these 17 comes.
Mine is maintainability in the locus. The locus of
That
this
has to be decided first. Then only you get the copy of the other application.
My lord.
And as
bow
per
down.
my application, my lord, I'm explaining for simplicity of prayer, appoint the advocate commissioner to record
We'll
the
see that.
evidence.
But you like to file an opposition to this application?
My lord, I have to, because this is the absolutely a
Mr.
frivolous application, my lord.
Mr. 16 Ekuru, Mr.
And my
Spenso,
maintainability point should be
done
kept
it.
in open, my lord.
Advocate, or you are representing plaintiff.
Yes, ma'am.
Plaintiff is respond number?
Both the plaintiffs.
Plaintiffs.
Plaintiffs. Representing the plaintiffs seeks to file affidavit in opposition to the application. Let such affidavit in opposition be filed within a period of 2 weeks. Reply thereto within a week thereof. List this
Kindly, my lord, keep the maintainability point open, my lord,
Ah.
because
matter after 3 weeks. Huh?
Obliged.
The point of maintainability
grateful,
of
my
the
lord.
application is kept open and will be decided at the final disposal of the application.
Obliged.
এটা লিস্ট এটা হলো তো লিস্ট along with নেক্সটটা করবেন একসাথে আসবে লিস্ট
Obliged.
Okay.
But that's what my application is concerned, my lord. In the same day or
On the same day. On the same day. Let me first decide.
2010 suit, my lord, is just delaying it because of this applications, my lord. Frivolous
Ah.
application.
My lord, first, my lord,
Kindly-
GA16 has to be decided. That's my submission, my lord. Without that,
16 is to be
16
decided.
has to be decided. Because my predecessor in interest also filed an intervention application. The dismissal for default happened after the death of my predecessor. He had died in January 2024. His application was dismissed in November 2024. So these points have to be
I'll
decided.
show
my lord,
you
before-
that they have all the applications are filed with all the false documents. I'll show you in my evidence.
Come up with
Kindly, this the 17 also be coming the same.
same day.
My lord, grateful. 2 weeks. Grateful. 27. I'm grateful.
Item number 5.
I prefer to
This is
respond.
our application. Your Lordship, since this is our application, Your Lordship may hear us. And subsequently, whenever the other side, the interveners, that they want to hear, they can address our submissions. Because this application has been pending for very long, Your Lordship, and all the pleadings have been complete.
You are for?
I am appearing for the notice number 10 and 11.
And this
whole defendant passed away in
Your Lordship, may I
1989,
just, before
and we are the notices of this application, which is in effect recalling of order of dismissal of this suit.
you have filed your opposition to this.
yes, yes.
No. Okay.
Your Lordship, this is our application for restoration pursuant to the liberty granted to us by an order dated 26th February 2024.
26th February,
This is annexure A, Your Lordship, at page 15.
page 15.
Yes, page 15, Your Lordship, by the Honorable Division Bench of Justice I.P. Mukherjee and Vishwarap Chaudhary, Justice Vishwarup Chaudhary. Your Lordship, it's an important order that Your Lordship, the Division Bench has passed. I would like to place this order before Your Lordship. Your Lordship, may I just place it? On the facts narrated in the application IAGA number 4, 2023, His Lordship cannot be faulted. Your Lordship, this application was an appeal for setting aside an order by Justice Shugato Majumdar, passed in 16 September 2022. On the facts narrated in the application, His Lordship cannot be faulted for thinking it was one for restoration of a suit dismissed for default on 16 September 2022, for restoration of which the said application was filed on 6 September 2023. Considering the delay and the absence of explanation, His Lordship was pleased to dismiss the restoration application on 13th October 2023. The facts which are not placed before the court are these. The plaintiff number 2 died on 27 June 1982. The plaintiff number 4 on 22nd June 2007. The plaintiff number 1 on 26th August 2008. And the plaintiff number 3 on 17th September 2021. The defendant died on 11th, the sole defendant, Your Lordship. The defendant died on 11th February 1989. His son, not substituted as a party, died on 13th February 2005. Mr. Suman Kumar Dutt, learned counsel appearing for the appellant, submitted that shibayatship of the above plaintiffs was joint and several, and even after the death of a shibayat, the right of shibayatship continued to vest in the living shibayats. The last shibayat died on 17 September 2021, being plaintiff number 3. Therefore, when the suit was dismissed for default on 16 September 2022, the suit may have abated. It was not a case where the plaintiffs or the learned lawyer engaged by them failed to appear before the court when the suit was called on for hearing and the suit was dismissed for default. Also relevant is the question whether during the lifetime of 3 shibayats, plaintiff number 1, 3 and 4, the suit had abated against the defendant who had died on 11th February 1989. Assuming Mr. Dutt's above contention to be correct, that the right to sue survived in the surviving shibayats. All these questions need to be appropriately addressed before the court on a proper application in this behalf having been made. Having made these observations, we hold that on the facts pleaded before the court, there is no infirmity in the judgment and order dated 13th October 2023. But on the facts argued before us in appeal, we grant liberty to the appellant to take out an appropriate application before the learned trial judge. If and when such application is made, the same will be considered without being influenced by any of the observations made in the order dated 13th October 2023. The appeal and the stay application are disposed of as affidavits. Your Lordship, may I place the facts of this case? The original CS number 163 of 1977 was pursuant to a suit, a trust property, being 35 Ganesh Chandra Avenue. Your Lordship, one owner, one settler, Ratnabala Dasi. Your Lordship may come to page number 31. This is the deed, trust deed, executed by the settler, one Ratnamala Dasi, in the year 1944, Your Lordship. Here, she had appointed her maternal uncle, one Mrinal Lal Malik, as this original trustee, as a trustee of the suit of the suit property being 35 Ganesh Chandra Avenue. Subsequently, a year later, the said Mrinal Lal Malik passed away. Thereafter, his sons, the plaintiffs herein in the present suit, were running the trust property. Subsequent thereto, in 1960, the said settler had executed a second trust deed, appointing the plaintiffs as the trustees for the said property. Your Lordship, the trust deed is being executed Your Lordship, may I place Your Lordship may come to page number 32. Page number 32, last paragraph, Your Lordship. And whereas the said, Your Lordship, is on page 32, the last paragraph, Your Lordship. The said settler has great reverence for the deities Sri Sri Singha Bahini Mata, Shingo Bahini Mata, with her 10 accompanying deities, namely the following are the names, Your Lordship, and of the well-known Malik families of Calcutta, and whose worship is performed by the members of the said family in turn allotted to each branch of the said family, and also for Sri Sri Radha Govindo Jiu, with Narayan Shila being the family deity of the heirs of the late Abhoy Choran Malik of Calcutta, hereinafter collectively referred to as the said deities. So, Your Lordship, this property, the trust. And whereas since the infancy of the said settler, the settler attended on all the daily and periodical ceremonies during the Pala or turn of worship of the said Purnachandra Malik, son of Singhadev Malik, Singhodas Malik, deceased of each of the said deities. And whereas the settler hath for a long time cherished the desire and intention of creating a trust for the worship of the said deities during the pala or turn of worship of the said Purnachandra Malik, with a view that the same day be observed with great pomp and grandeur, including therein the purchase of such paraphernalia for the worship of the said deities during the pala of the said Purnachandra Malik and of his heirs as the said trustees or other the trustee of these presents hereinafter named may in his absolute discretion think fit and proper. And whereas with a view to give effect of the aforesaid desire of the said settler and for the consideration aforesaid the settler has intended to execute these presents in the manner hereinafter contained. And whereas the said settler had not at any time done any act, deed, matter, or thing, nor is indebted to any person or body whereby or by reason whereof she may be prevented from executing these presents in the manner hereinafter mentioned. And whereas for the purpose of your lordship on page 34, may your lordship come on the second paragraph. And now this indenture witnesseth that that in pursuance of the said desire and for the purpose of giving effect thereto, and also in consideration of the reverence which the said settler hath and bears towards the said deities, and for other good causes thereunto, moving she the said settler doth hereby absolutely grant, convey, and transfer unto the said trustees all that the brick built measure land your lordship, may your lordship come on the second page, being page number 35. To have and to hold the said trust property with their appurtenance unto and to the use of the said trustee, but subject nevertheless to the declarations, trust agreements, and charges for the several ends, intents, and purposes hereinafter declared and expressed of and concerning the same, that is to say, to collect the rents, issues, and profits of the trust property, to disburse the collections to be made as aforesaid in the manner and in following, that is to say, to pay the collection charges and charges in connection with the management of the said trust property and other outgoings, including the cost of repairs thereto, to pay the municipal rates, taxes, and other impositions in respect of the said trust property, including income tax or such other impositions which are or may be levied thereon, to pay the balance to the settler during the term of her natural life, each and every month within a week from the date of the collection to be made as aforesaid. Your lordship, may I just place your lordship that on page your lordship, now may come to page number 39, your lordship. Beg your pardon, your lordship. 38, page number 38.
Yes.
And it is hereby further declared that if the said trustee hereby appointed or any further trustee or trustees of these presents shall die or desire to be discharged from the trusts of these trusts of these presents, or refuse or decline or become incapable or unfit to act in the execution of these trusts, then in such case it shall be lawful for the said trustee or other the trustee for the time being of these presents to appoint b any deed or will any other person or persons or the official trustee of Bengal to be the trustee or trustees of the presence in the place and stead of the trustee so dying or desiring to be discharged or refusing or declining or becoming incapable or unfit to act as aforesaid, and in making such appointment the trustee shall be at liberty to exercise his full and absolute discretion in the matter, and upon such appointment the said property shall vest in the new trustee or trustees as the case may be, as if such trustee or trustees had been originally appointed by these presents, and the trustee shall have power to comply with such requisitions as may be lawfully insisted on by the said official trustee for making over the trust property for management as such trustee, provided that in default of the said trustee failing to exercise the power of appointment by will or other document, or in case any vacancy or disqualification occurs and it is found impracticable to appoint a new trustee, the High Court of Calcutta shall appoint a trustee from amongst the heirs of the trustee appointed hereby, who may be found to be best qualified to discharge the duties of such office. Your Lordship, this is the deed of trust executed by the settler dated 1944. And as I earlier mentioned, Your Lordship, subsequently, and on page 41, Your Lordship will see that she had again executed a deed dated 1960, appointing the plaintiffs as heirs. If Your Lordship comes to page number 41. This is the second deed that she had executed. Your Lordship, a decade later, the heirs of the settler say that the settler had subsequently executed a deed dated 1970 and another deed appointing her second son also. By deed dated 1970, she had appointed her elder son. By a subsequent deed, she appointed her younger son as well. And they allege that there was a power of attorney also executed by the settler, appointing the second son to do as he may deem fit. Thereafter, Your Lordship, on Your Lordship, on 23rd August 1974, Your Lordship, the settler dies. Subsequent thereto, this present suit dated 1977 was filed by the plaintiffs, challenging the subsequent deeds executed by the settler. So these were the prayers that under which the present Your Lordship, may I'm being led by Mr. Suman Datto.
That the order of the division bench, my lord, I'm not saying that it is binding because nothing has been held to be conclusive in that. But it says that the order for restoration, the order of which I am seeking recalling today, has to be looked at from the point of view whether the right to sue survives. Now, the order of dismissal, my lord, if your lordship, my lord, comes to that page 89.
All the plaintiffs have expired.
Yes, all the plaintiffs have expired, and the last of the plaintiff expired in 2021. And therefore, when 2021, Millard, thereafter, when this application was filed and this order was passed on 16th of September 2022, Millard, it is not a case that, Millard, the suit has abated in the sense that I could not have come and made an application for restoration of the suit by the subsequent legal acts. What had happened is this, Millard, the learned judge was of the view that none has been appearing on behalf of the parties. It doesn't say the plaintiffs. None appears on behalf
Where
of
is
the
it?
parties.
Order.
Page 89.
Yes, only one thing, but may I take Lordship's leave? Lordship, my junior is here, Lordship. I have a fixed matter at 3 p.m. Mr. Dutt is opposing me there. I do not know.
Which one?
HON'BLE.
Start upcoming. Millard. So, Millard, this was dismissed, and Millard, page 96 thereafter. This is an application paying for restoration of the suit, I'm sorry, by one of the legal heirs of the deceased plaintiff. The suit was dismissed for default on 16 September 2022. That's the order at page 89. The instant application was filed on 6th of September 2023, almost after a lapse of 1 year. No cause is shown as to why the existing plaintiff did not take any steps. It is in the application that the plaintiff number 4 expired in 2007 And the plaintiff number 1 expired in 2000. One expired in 2000. And the plaintiff number 2 expired in 82. It appears that the plaintiffs are not interested to proceed with the suit. This is not a proper case for restoration of the suit. GS so was dismissed. Now, my lord, when this order was passed, your lordship will find that in this application there was no prayer for setting aside abatement. There was no application for addition of parties. Nothing was there. So it was a sketchy application, which, my lord, in my respectful submission, was rightly dismissed, and the appeal court has also had. But, my lord, the greater picture is something else. The greater picture is, my lord, parties proceeded on the basis that the suit was essentially a fight between trustees. But what was not brought to the notice of the court, that the suit was initially for a declaration that the property is a trust property, and that who would be the trustees. Now, the persons who were contesting the suit, my lord, were contending that we were entitled to the office of the trust. But that does not take away the underlying admission by both the plaintiff and the defendant that this is a trust property. And that the trust property was charged for the purpose of Dev Shiva and Dev Puja of the deity. Now, my lord, if this is the trust, and the 1944 trust says that I do hereby grant, convey, and absolutely transfer, my lord, the first principle of trust is that once the settler divests himself of his interest in the property in favor of the trust beneficiary, my lord, he doesn't retain any control over the trust property. He is already divested. And the 1944 deed which my learned junior placed, my lord, expressly says, I do hereby grant, convey, and transfer. So this trust deed is not in dispute in the suit. What happened is, my lord, once the suit was filed, this court in its wisdom, and rightly so, my lord, appointed a receiver straight away. The receiver which was appointed on this property, my lord, was entrusted with the duty to be on the property. That's very important. To be on the property. The property will vest in the receiver. He will collect the rent and use it for the purpose for which the Dev Shiva and Dev Puja is. That was the desire. And the trust deed also provides that in the event, my lord, there is a dispute between the trustees, the High Court, being, my lord, the deity being a perpetual minor, my lord, the High Court exercises jurisdiction of parents' jurisdiction over the deity. The High Court will appoint a receiver. So, my lord, my respectful submission was that this suit, in the form in which it was framed, where the court has already exercised and appointed a receiver to run and administer, could not have abated just like that. If there was nobody, even for argument's sake, my lord, then the High Court was a duty bound, my lord, even in this suit, my lord, to step in, if it had been brought to the notice of the court, to step in, appoint trustees, and make the let the Dev Shiva continue, because the High Court is the ultimate custodian of all these details. Surprisingly, what has happened over here, my lord, we come to know that during the pendency of the suit, when these disputes were pending, one of the trustees who had died, my lord, their legal heirs have sold and transferred the entire property to a third party. And that third party is the intervener who is now trying to come in and protect. So, my lord, at the very outset, my lord, there is a... Yes, I'm not suppressing anything. So, my lord, today, my learned friend who wants to intervene in this suit, my lord, only goes to show that there is a dispute involved. Number one. The question is whether the dispute is to be involved in this suit. My answer would be yes, because of the simple reason that the receiver which was appointed was never discharged. Your lordship knows, my lord, that a receiver can continue even after dismissal of the suit. That's the Supreme Court judgment of your 1960s, which continues. So what had happened is this, my lord, my learned friend's clients have joined hand in glove with one of the defendants in the suit, purchased the property, which would be an assignment within the provisions of Order 22, Rule 10, pending a suit, and have kept silent. He has never come forward to join the suit and uphold his rights, because he knew
that the trust property could not be purchased like that. It's a property which was charged to the deity, and therefore the sale, and over and above that, there was a receiver appointed over the property vested in the receiver, and therefore the sale would be interference with the possession of the court as well as of the receiver. So they chose to keep quiet. They did not come forward to contest. Only they saw that the suit was not being attended, and if it gets naturally dismissed in due process, then obviously there is nobody to challenge. Now, luckily, Milord, for the deity, Milord, who is the legal heir of one of the trustees, Milord, have now come forward to protect the interest of the deity. And that is the paramount interest that is left in the suit. Because the initial contest, suppose, Milord, two trustees are fighting. The parent, the primary concern of the court is to protect the trust property, whatever may be the outcome of the fight. But it cannot be the intention of the court that till such time the trustees are fighting during their lifetime, the property is sold off to a third party. But here that has exactly happened. And Milord, this legal heir of my, which is the petitioner before your lordship, Milord, has now come forward seeking the protection or interference of the court to ensure that the trust property is being protected. And Milord, I shall show authorities that the courts have all the powers to undo any act which has been done in teeth of the subsisting orders of. That's the reason, Milord, why. Where's the order? Post. That's the reason why, Milord, the division bench, Milord, in its wisdom thought, when I brought these topics, when they brought these things up.
Original plaintiffs were the persons in whose favor this settlement was made by the
settler.
The legal heirs have come forward for restoration.
One of the legal heirs now have. There were 3 trustees. Now,
and in the suit, the subsequent trust deeds have been challenged in the suit. This is the fact.
This is the fact.
Okay.
Now, so far as the subsequent trust deeds are concerned, the person who was setting up these trust deeds, who was the defendant, that I have a subsequent trust deed and I am the, he passed away. And his legal heirs, instead of getting themselves added or bringing it to the notice of the plaintiff that we need to contest, they assume the right from the deceased defendant and they sell off the right.
Deriving their rights from the subsequent trust deeds, which has been challenged in the suit. Okay.
And now my learned friend says that I am a purchaser of that property for value. Oh, wait, don't get.
You will make your submissions when your turn will come.
Well, your lordship will kindly make a note of this submission because that helps. What my learned friend is otherwise saying, that he was aware of the suit. That is why he did not purchase the property when the suit was alive. So according to him, he had a right to purchase the trust property if there is no litigation.
Please, sir, please. You let him complete first, you make your submissions after that.
Now, if all trustees died, the trust does not come to an end. That is why the High Court has been given the power to appoint trustees. Now, my lord, actually, how do I show it to the people? Trustee. Why is it marked?
The applicant is the legal heir of which of the plaintiffs?
Milord, the defendant number, plaintiff number 3. I am son of
Plaintiff number 1.
plaintiff number 1. Sorry, Rabindranath Mollik. Proper list. Now, my lord,
Yes.
now, my lord, my learned friend's client, give me the translate from their opposition. Now, my lord, my learned friend's clients claim to have purchased the property by a. Why are you showing me this? Claim to have purchased the property on 3rd of August 2011. The deed is at page 62 of the petition.
3rd August
2011.
No. But at that time, the suit was pending. The
I'll come. Okay. Okay.
property transferred. Yes. 3rd August 2011.
2011, they say. Now, my lord, what had happened is this, my lord. My lord, a few dates, my lord, I'll just tell your lordship, these were not.
Just indicate the legal years of defendant. Which defendant has transferred the suit property?
The defendant number. Just a minute. My lord, he would be the defendant number 2, whose name was struck off, Lal Mohan Mullik, whose name was struck off from the suit register by an order of Justice Kodma Kastagir, as his lordship then was, on 25th of March 1980.
March 1980. Yes.
Now, thereafter, my lord, a few dates would be relevant for your lordship's consideration. My lord, my learned friend keeps on saying that the suit was dismissed. The suit was dismissed for default on 13th of June 1997. Ordered at 74. Give me the page now. Thereafter, my lord, it was restored on 17th of June 1997.
Yes.
But why is it burnt? My lord, this is original piece of evidence, my lord. There was a fire, my lord, in which we could just barely get hold of the certified copy. It shows that the suit was restored immediately thereafter.
Yes.
Now, my lord, thereafter, I'll give a bunch of these orders. This is all that came subsequently transpired, my lord, after that application, previous application was filed. 3rd of August 2011, my learned friends purchased the property.
Yes.
Now, thereafter, on 26th of March 2019, the suit was dismissed by Justice Saraf. 26th of March 2019.
2019.
Now, my lord, when this suit was dismissed, Justice Saraf's order, give the order. That's it. You do one thing, you keep one copy and send me one copy. That is not required to see a copy. Give me a copy. Well, what Justice Saraf went through, Milord, was that he was under the impression that the 13th June 1997 dismissal order was still subsisting. Give me Shipkan Prasad's order. So that's why my lord was not aware of the fact that subsequently the suit was restored. So he said that let it be struck off. Now, my lord, when that was done, my lord, we filed an application in 2019 where, my lord, this was brought to the notice of the court and the order of Justice Saraf, my lord, was recalled. You keep one copy for yourself. How do I show it to the court? You're not relevant. Then what are you doing? What's going on over there? I think I go to the take note.
Yes.
So, my lord, my learned friend's contention that the suit was dismissed as on the date when he purchased is incorrect. Suit was restored. Factually, in the records, it shows that Justice Saraf's order, which he could not be bothered with. He cannot say that I was misled by the order of Justice Saraf. He couldn't have because he purchased it long back in 2011. So, all that he could do was, my lord, that he had most probably gone and found out that the suit was dismissed from the website, did not cause any searches, and he purchased the property. But in the process, my lord, he admits two things. One is that he could not have purchased the property without the leave of court, because that's the reason why he made this search. And when he comes and says that I have purchased the property when there was no list pending, goes to show that he was aware that the property was under custodial legis. Otherwise, why will, my lord, he will come to court for the purpose of trying to get an order from court or make a search to the court. And he now says that there was no suit. And in fact, my lord, this submission was also made, which has been recorded, my lord, in the order of Justice Shipkan Prasad, that this was a submission that was made that there was no suit pending. But he cannot be a bona fide purchaser for value because of the simple reason his deed itself records that this was a trust property, which was dedicated for the Dev Seva and Dev Puja. Go to that. I know.
Where is his deed?
My lord, this sale deed, my lord, by which they claim the right is at page 62. Kindly see what is the reason. Kindly come to page 66. Your lordship is at 66, and whereas?
Yes.
And whereas Ratnamani Dasi, that is the settler, son of so and so was deceased, absolutely seized and possession when entitled to the sole owner to the premises being partly 3-storied and partly 2-storied, built together with piece and parcel of land thereunto, containing an area of 4 cut and 9 chataks 4 square feet, BSM little more or less situate and being premises number 35 Ganesh Chandra Avenue. And whereas by an indenture of 18 September 1944, kindly mark Milord, this is the first deed, trust deed, registered in the office of the registrar such and such, Ratnawala Desi has settled and created a trust in respect of the said property, appointing her uncle Mrinal Lal as the trustee. Whereas that Mrinal Lal Mullik died on 46, following which the office of the trustee fell vacant, and Ratnawala Dasi by an indenture of 14 March 1960, registered with the office of the assurance Calcutta such and such, appointed as trustee 4 of her sons, Mrinal Lal Mullik, Robindranath Mullik, Birendranath Mullik, Jitendranath Mullik, and Dhirendranath Mullik, who were jointly entrusted with the rights and duties and functions of the trustees. Then, and whereas the joint trustees had been neglecting in performing their duties as trustees properly and also had not been taking any care of the settler, who has only been the beneficiary under the trust, the said Radhadeshi by an indenture of 24th April 1970. This was the dispute. 1970, registered at the office of the assurance Kolkata, appointed her eldest son Balaram as one of the trustees of the existing trust and empowered him to exercise or join in exercising all the trust powers and authorities under the trust of the existing trust jointly, along with the 4 above-named existing trustees. So, Milord, it's an admission that the trust was not revoked, could not have been revoked. So, another additional trustee was put in. Okay. And whereas Ratnawala Dasi subsequently by an indenture of 1970 appointed her young son Lal Mohan Mullik as one of the trustees. So, another trustee gets appointed. Very good. Whereas by an indenture of 73 registered with the office of registrar executed such and such representative constituted attorney, Lalmohan Mullik by virtue of a registered power of attorney dated 31st May 1973 of the said Ratnawala Dasi cancelled simultaneously the indenture of 1460 and the indenture of 24th April 1970. Appointing Rabindranath Mullik as the trustee in terms of the first Menden indenture and also appointing Balram Mullik as the joint trustees of the second trust. This would be an issue in the suit. Because if the original trust deeds go, the subsequent persons who were added as trustees, Milord, that means the extinction of the trust. Now, Milord, extinction of the trust could have been only with the settler, provided, Milord, she had not divested her rights. Had the original trust deeds said that I give everything, but I hold the right of office to me, then Milord, that's one way. But here she has divested herself absolutely. Once she has divested herself absolutely, there is no question of recalling or revisiting the trust. This would be an issue in the suit. Now, and whereas Lal Mohan Mullik was seized and fully possessed of the trust property mentioned in Schedule A hereunder, written as the only remaining trustee administering the trust property and discharging all duties and functions of the trust alone to the satisfaction of so and so. So he is the only trustee now because according to him all previous trustees have been revoked. Whereas Lalmohan, who was a Hindu governed by the died on 22nd May 1979, leaving behind his surviving sole widow Ranubala Dasi, Arun Kumar Mullik, and 2 daughters so and so and so and so. And whereas prior to his death, the said Lalmohan, declaring himself as the sole trustee of his mother, such and such, executed his last will and testament of 1st July, whereby he bequeathed all his movable and immovable property, including the property mentioned in Schedule A hereunder, to Ratnawala Mullik, Ranubala Mullik. How could it have been done? It's a trust property. And whereas the said Lalmohan Mullik did not name or appoint any executor in his will, dated 1st July 76, and Ranubala Mullik applied for letters of administration before the Honorable High Court at Calcutta, 1980. The Honorable High Court Calcutta granted letters in favor of Ranubala Mullik in respect of the properties of Lalmohan Mullik, including the said premises such and such. That is where, Milord, the property has now been brought in. I have no problem with Lalmohan's private property, but it adds including the said premises.
Yes.
Then, Millard, so therefore, Lalmon's property is invested by them, the four children. Millard, the last paragraph at page 68, where Oshim Mollik, Lokhi Shil, Dolly Mollik, the vendors herein are now seized and possessed and sufficiently entitled to the premises measuring 4 kata, 9 chataks, 4 square feet, which is more than 100 years old and dilapidated, partly 3-storied and partly 2-storied dwelling house, having a super built of area of 3,300 square feet, together with 100 years old and partly 3-storied, partly 2-storied dwelling house, having separate built up, super built up, so and so, agreed to sell, and the purchase have agreed to purchase undivided 1/8 share of the premises, being their number 35 such and such, herein or is said property. And thereafter, Millard, the sale takes place. So, Millard, this sale, Millard, could not have been done for the fact that what has been suppressed, page 57.
Yes.
Millard, the one reason is, Millard, when the suit was filed, Millard, this honorable court was pleased to appoint receivers. And Millard, at page 58, Millard, I shall carry on the next. At page 58, Millard, kindly see.
Fifty-eight.
58, your lordship, kindly see. Millard, it is ordered that remuneration of 15 gold modes, such and such, rents and issues, Ganesh Chandra Avenue, Calcutta, and remuneration of 15 gold modes per month be appointed receiver of the trust property, namely 35 Ganesh Chandra Avenue, and the rents, issues, and profits thereof, with the power to him to get in and collect the outstanding debts and claims due in respect of the property, and with all the powers under Order 40, Rule 1, Clause D of the Code of Civil Procedure, except that he shall not, without the leave of this court, grant lease of exceeding 3 years, bring suit such and such, such and such. Order 40, Rule 1D, Millard, in court entrusts the property to the management of the receiver. So long this order was there could not have been any sale. Number one. Number two, the suit cannot abate because it's the duty of the court under the 44th trustee, Millard, to appoint a trustee, because the income of this property, the rental income, is to go to the deity. So the deity is being deprived of the rental income by virtue of this sale. Number two. Number three, the trustee in the trust deed itself acknowledges deed of trust. And until and unless those contentions that this was revoked, that was challenged, are established in the suit, Millard, the subsequent procedures do not get a right. Now, Millard, all these things are still alive in this suit. All these things are alive. The fact that the trustee, the fact that the trustees have been coming and restoring the suit time and again only goes to show that the interest in the property has not been lost. Because this is on 35 Ganesh Chandra Avenue, Millard. It has been sold off by one person who has not. So, Millard, in those circumstances, Millard, when I show your lordship on the next day the first restoration application, nothing of this was brought to the notice of the court. Otherwise, Millard, no court is, Millard, so strict that unless there is lackadaisical attitude on the part of the plaintiff, will not restore the suit. And here, Millard, we are dealing with a perpetual minor. The interests of a minor are involved.
Okay.
Who will protect their interests, Millard, if the court does not permit? Millard, I shall continue on the next day, any day.
And also prepare a bunch of orders which
Yes,
you have
Millard,
sent. Previous orders will be also required. Awesome. But Mr. Shuman, the learned advocate, learned senior advocate appearing for the applicant. Yes. Applicant. Due to paucity of time, the hearing could not be concluded. বলুন কবে দেবো ফ্রাইডে উইক নেক্সট ফ্রাইডে তো রাখুন কবে হচ্ছে নেক্সট ফ্রাইডে টেনশন আগে দেখে নিন অন্য কোনো কিছু ফিক্স করে রেখেছি কিনা দেখি হ্যাঁ দিয়ে দিন লিস্ট অন 10 জানুয়ারি
My lord, may I permit to mention one matter
tomorrow
before rising?
tomorrow
My lord,
mention tomorrow sorry
only leave for issuance of master summons is required. In the except or exception of the office IO report.